Okay, so we're ready to go. We're live, and we've got Chief Mello, Paul Mclanson, and Chief State's Attorney Richard Colangelo up, ready to speak.
Okay, thank you, Deb. So I'd like to call to order this Judiciary Committee public hearing for Monday, February 22nd. We have two bills on the agenda for review. Before we start, anything from my co-chair? No. Rep. Fishbein, Senator. I don't even see the senator. Any comments?
No, sure. Thank you.
All right. Great. Thank you. So first up to testify is Chief Mello. Chief Mello, I see you. You may go ahead and begin. And let me just say, during the hearing, we will get a signal when the time to testify is over. We will put forward a gentle reminder and then a less gentle reminder. Hopefully everyone complies. The committee is really good at asking questions to bring out the information that's necessary. So I know sometimes people feel as though they have to get everything in, but that's not always a necessity. I'm sorry, Chief Mello, I didn't mean to cut you off. I just wanted to remind people. You may go ahead.
That's okay. Thank you. Good morning. And if you don't mind, I'm going to read from written testimony, and then I'll submit a copy to the committee. Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Keith Mello. I am the Chief of Police for the City of Milford and the Chairperson of the Police Officer Standard and Training Council, having been appointed first by Governor Malloy and then reappointed this year by Governor Lamont. I also serve on the Legislative Task Force on Police Accountability and Transparency and the Connecticut Bar Association Task Force on Police Reform. I'm also the immediate past president of the Connecticut Police Chiefs Association. And I'm here today representing the Post Council to speak in favor of Raise Bill 6462, an act concerning the use of force by a peace officer. Specifically, the amendments to Section 29 of Public Act 20-1, known as the Act Concerning Police Accountability. We recognize that police officers are vested with extraordinary authority to use force to achieve the lawful purpose of protecting lives of others and to protect themselves. With this authority comes great responsibility to exercise sound judgment and restraint, using force judiciously and only to the extent necessary. Everyone must certainly agree that physical force must be considered a necessary and last resort only when there is no reasonable alternative available under the unique circumstances that each interaction presents. Deadly force must only be used to avert life-threatening danger and only when there is no reasonable alternative. And please note the emphasis on reasonable alternative. Before this legislature publicly introduced any legislative proposals during last summer's session, the Post Council voted on June 6, 2020 to establish a subcommittee to create a mandated use of force policy and training program for all Connecticut police officers. We did so because we recognize the need to provide police officers with stronger guidance and direction when making life-altering decisions to use force on another person. We focused on holding officers accountable who intentionally break the law and who violate their oath. We focused on providing officers with better tools to make use of force decisions, often under very stressful, rapidly evolving conditions, and most often with imperfect information. Decisions that they must often make in seconds, but decisions that we as police chiefs, the media, the courts, and the public will dissect literally frame by frame, second by second for months and years. We focused on some of the very issues that you addressed during your deliberations for Section 29. A peaceful resolution is always the most desired outcome, and our training and our culture must reflect that goal. A continued and renewed focus on the art of de-escalation and diffusion strategies is an imperative, and our policy and our training and our culture must also reflect that goal. The sanctity of human life and the respect for every person's rights and dignity must be reflected not just in the application of force, but in everything we do. And so with these values as a framework, we also must remember that police officers have a very difficult job. We must support them by providing them with the clarity in the law, the clarity in our policy, and the clarity in our training. During the post committee's work, they found certain aspects of the statutory language to be ambiguous and difficult to interpret. Our goal is to prevent confusion and provide for a consistent application of the law, of the policy, and of the training. I believe that we can accomplish these mutually agreed upon goals through policy and training. So I come here today with support of the Post Council and the backing of the Connecticut Police Teachers Association, although you should hear from those representatives who will be here later this morning. I come here to support changes to section 29 in 5 key areas. In my view, these changes don't in any significant way alter the intent of this section, but they do provide clarity to police officers who unfortunately may have to someday use force to save a life, including their own. I hope you agree that it's vital that our police officers have a clear understanding of the potential criminal liability and the intent of this legislative body when you crafted the original bill. I believe the changes reflected here in 6462 are consistent with that original intent. And I'll quickly highlight those changes for the record because I know you have those in front of you. The first one, line 1265 of PA 20-2 reads, he or she has exhausted the reasonable alternatives to the use of deadly physical force. We are asking that the word exhausted be substituted by the word considered. The line will then read, he or she has considered the reasonable alternatives to the use of deadly physical force. Some can certainly argue that the term exhausted, the reasonable alternatives is saying the same thing as considered. But our concern is that the word exhausted creates an expectation that a police officer will have to progress through other alternatives.
Chief Mello?
Yes.
I'm going to, because I know that question is going to come out, so I'm going to just move us in because your 3 minutes are up. I tried to give you a gentle signal, it wasn't
Okay.
heard. And I know that question is going to be asked during me. So let's move into the question phase.
Sure.
And then you'll definitely get an opportunity to explain that. So I'm going to start off with, I see Representative Howard, followed by Representative Fishbein. Representative Howard.
Thank you, Mr. Chairman. Good morning. Good morning, Chief. How are you?
Good. Good morning.
Chief, thank you for your service, not only to the city of Milford, but your continued service to law enforcement statewide and your continued effort to raise the bar in the profession. It's much respected and appreciated by me.
Thank you.
If I could, just for a few minutes of your time, down in Milford where you live, or where you work, I guess I should say, there's a Walgreens on Route 1. Just west of that is a CVS, and west of that is your PD. Do I have that about right geographically? I'm from the other side of the state.
You do. That's correct.
All right, perfect. If we can for a minute, if we suppose that you had a shooting at the Walgreens, and you had just recently gone to, say, the CVS there for whatever reason, then you go back to your PD, to your office, and as you pull into the parking lot, you hear the radio call for the shooting. Is that something you would immediately respond to as a police officer?
It is.
All right, so, and I assume your detectives would, in the course of their investigation, grab surveillance probably from the Walgreens and the CVS and surrounding businesses. Is that fair to say?
That's correct.
And when they did that, if they were able to determine at the moment that shooting took place was the same moment you were at CVS, then one could argue that your leaving CVS and going to the police department before responding was a delay in response, couldn't they? In other words, if you had left CVS and taken a right and gone directly to Walgreens, you would have gotten there a lot quicker if you hadn't gone to the PD first, right?
Of course.
But you didn't know that the shooting took place until you hear the radio call, correct?
Of course. Sure.
So would it be unreasonable for me to judge you and say you delayed your response when the fact is you didn't have that information until you got to the PD, correct?
Yes, it would be unreasonable.
Chief, do you train your officers in use of force, or somebody in your PD does?
We do.
And when you do that, you train them in the Connecticut statutes related to use of force?
We do.
And your department policy?
That's correct.
And case law?
That's correct.
Because all those things basically govern how an officer uses force in Connecticut. Is that correct?
They do.
And Chief, are your officers trained in the Supreme Court case of Graham v. Connor?
They do.
You're familiar with that case, right?
I am.
So in that case, the Supreme Court ruled that when you judge an officer's use of force, it has to be a reasonable inquiry, objective, that is objective in light of the facts and circumstances confronting the officer. Is that about what you train them in?
Yes, known to the officer at the time.
Well, interesting. So the Supreme Court also caution that objective reasonableness has to be judged on the information known to the officer at the time and not with the benefit of 20/20 hindsight, right?
That's correct.
Now, you're testifying on 6462, which the amendment here, it does say that the officer will be judged with objective reasonableness under the circumstances, but the words known to the officer at the time are notably omitted. Do you know why that is?
I do not.
Well, that leaves the door open to take information that becomes available after and use that in judging the officer's decision that he made at that time. So you testified when we gave you that scenario that it would be unreasonable for you to be judged in a delayed response when in fact you had no information that the shooting had taken place at Walgreens. Wouldn't it be fair for the officers in Connecticut to be afforded that same fairness to be judged on their decision based on the information they had at the time they made the decision?
I agree. If I could add, not having the benefit of a legislative history because of the pandemic and the lack of multiple hearings through multiple committees, I am not sure whether or not it was the intent of this committee to completely depart from Graham v. Connor. It was my understanding, and this might be a good time to get on the record, that the original premise established in 1989 by Graham v. Connor is still present, but for the addition of additional factors in the section that says including but not limited to. Am I wrong on that?
No, well, I think that you're correct, except that the bill language today, as it sits before us in 6462, which is consistent with 6004, has omitted seemingly the important words known to the officer at the time. So my question to you, Chief, based on all of your experience, would it be appropriate for those words to be added to that language?
I think it would be helpful, but I would also say that I would certainly hope that the court would refer to Graham v. Connor when they're determining what objectively reasonable is, because objectively reasonable is a difficult standard. I mean, it was, I believe, is it the Bell case or the Wolf case that said that objectively reasonableness is not subject to a precise definition or mechanical application. So I would hope that the guidance would come from those earlier cases. And I would hope, and it was my understanding, and it is my understanding, that the inclusion of the additional but not limited to, while still presenting some concerns, because not limited to is an unknown, that just placed those additional requirements.
Well, when you consider the way that could be interpreted, Chief, and I think we both agree, I know we both agree that what we want here are police officers that use deadly force as an absolute last resort when it is objectively reasonable given the circumstances they're faced with. I think we agree on that statement. Is that fair?
Absolutely. And the policy that we created certainly reflects that in very strong terms.
Correct. And so do you think that the addition of those words that would just solidify that the officer can't be held to information not available to him would in any way harm our goal of keeping that accountability?
No, I do not.
Thank you, Chief. No, Mr. Chairman, I thank you for the time. Chief, again, thank you for your service and thank you for your testimony here today.
Thank you.
Thank you, Representative Howard, Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Chief. Nice to see you again.
Good morning.
Chief, you were testifying about a portion of the bill that you were making suggestions should be changed, and you may have addressed that in some of your responses to Representative Howard, but if you could just point me back to where specifically you were addressing within the bill and what you were, if you could just close that statement.
Great, thank you. So there are 5 key areas, and with the first area being line 1265, and I know you have the bill in front of you so you can understand the context, where the term is used in the bill, he or she has exhausted the reasonable alternatives to the use of deadly force. And we are asking that the word exhausted be substituted with considered. And as I had said, I started to say that I guess you could argue that the term exhausted the reasonable alternatives is saying the same thing as considered. But our concern is that the word exhausted it creates an expectation that a police officer will have to progress through all their alternatives before they can move on to the next alternative. And that's just clearly not always possible. All their alternatives should certainly and thoughtfully be considered, but the officer must respond in a manner that is proportional to the threat. To expect a police officer to try lesser responses that are disproportionate and ineffective places his or her life or the safety of the public at risk. In fact, it was the National Consensus Policy and Discussion paper on the use of force that stated that they recommend language that officers should only use force when no reasonably effective alternative appears to exist. So that was the first one. The second concern was in line 1265, beginning on line.
Not to interrupt, but just to be clear, because
Sure.
I think you misspoke. You were dealing with line 16 with regard to that prior.
I'm sorry, I'm referring to line 1265 in the original of PA 20-1.
Okay, I'm looking at the bill that's before us, sir, which is 6462. So I'm looking at line 16. So just to orient myself and others for the record, we're looking at section 2, C1, parent large B, correct with that?
Correct. I don't have the line numbers in my copy, so I was referring to the line numbers in the original bill, but you're right. It's where it says he or she has exhausted the reasonable alternatives. It begins with that.
Okay, thank you. And then the next one, sir?
The next one, again, I'm referring to, because I don't have the line numbers, line 1267 in the original bill. I apologize that we are in two different documents. And it reads where it begins with reasonably believes that the force employed creates no substantial risk of injury to a third party. Do you see that?
Yes, sir.
Okay. We're asking that the word substantial be replaced with unreasonable. The line will then read, reasonably believes that the force employed creates no unreasonable risk of injury to a third party. And our thinking on that is this. When we think of substantial, we think of significant, considerable, or consequential. And I want to just preface by saying I apologize for talking about deadly force in such a mechanical way, but we don't have a choice. When a police officer uses deadly force by discharging a firearm, there's always a present danger that that bullet will miss its target and it will continue to travel for long distances until it strikes something. It could strike someone or it could eventually fall. So for a minute, just consider the suspect who has just committed a felony involving the infliction of serious physical injury to another person. And arresting this person or preventing him from escaping may save lives. And you recognize this because you have already allowed for this in the bill. So instead of substantial, using a commonly accepted standard of reasonableness, we believe is more appropriate. In fact, you've used the word reasonable throughout the entire bill, the entire document, and it's a longstanding legal principle. So you have recognized that standard. And on the next item, it begins, I'm in line 1282, but so you can orientate yourself. It says where we talk about deadly weapon, it's the conditions by which you're evaluating the officer's reasonableness. And it talks about, did the person possess or appear to possess a deadly weapon? What we're suggesting is, in supporting, is that you add the term dangerous instrument as already defined by Connecticut General Statute 53-3. It's in our criminal statute. It's, and I'll just read the pertinent part, the first part of the definition, the legal definition. Dangerous instrument means any instrument, article, or substance which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. The legal term, dangerous instrument is present in many of our serious assault statutes. And certainly police officers should have the same protection. A person can kill a police officer with a bat or a pipe or other instruments that are included in our state's legal definition. They can certainly kill another person. And we know that because we have seen that, of course. And then the final language change, and I'll begin on line 1286. However, any conduct, and we're in the same category now, we're talking about those additional factors by which we judge an officer's reasonableness. And you have the context there, but it says any conduct of the police officer. You see that?
Yes, sir.
We're asking that the word unreasonable be placed in front of conduct. And the line will read any unreasonable conduct of the police officer. I realize this may already be implied, but we're seeking some clarification in the language. And then finally, we are asking the deadline of April 1st of this year be extended to October 1st of 2022. And if I could give you the rationale, I think this is very important.
Please, thank you.
Post-council use of force committee crafted and mandated for all police officers in Connecticut use of force policy that even went beyond what you've put in the statute, provide greater specificity and greater direction. They needed 5 months to complete their work. That piece represented the first phase of this project. And the goal of the project was to improve outcomes, to better guide our police officers on the use of force. We're now entering the second and final phase, and that is a plan to develop a state mandated training program that reflects the policy and that reflects the statute. I expect that piece to be completed by the last quarter of this year. The next step involves the post-academy training every certified use of force instructor in this state on the new policy and the new training program. The final step will require that those trainers then go back to their individual departments and their regions and train every single police officer in the state. There's nearly 9,000 police officers in the state, and we're confident we can have that completed by that October 1, 2022. I think it's important to remember that our goal is to, along with you, to improve Connecticut's use of force statute, the statute you enacted last year. We're not here asking that it be repealed. We're asking that it be improved and that we clear up the ambiguity and we provide greater clarity. Because we're now faced with the task of training police officers to operate on this new legal standard. And this represents a change in a long-standing principle by which every Connecticut police officer has previously been trained, some for many, many years. And because, as we just discussed, Section 29 departs in some areas from those principles established by the Supreme Court in Graham v. Connor and Tennessee versus Garner, which were decided in '89 and '85, respectively. It's critical that we have the time and that so we can provide clarity, direction, and guidance to our officers, and that helps keep them safe and helps keep police officers safe.
Well, thank you, sir.
Thank
Just to go back, the use of force committee that you testified about before, who was on that committee?
Sure. So it was the chair was Dwayne Lavello, former chief of Darien. He's a member of the Connecticut Bar, and he's the current director of security over at Yale University. He is the former chairman of the Post Council, and he's done quite a bit of work, and we share a lot of common values and visions of where we think law enforcement should be. Professor Tracy Mears of Yale University and the Justice Collaboratory at Yale, who is a national figure. She served on President Obama's 21st Century Task Force on Policing and is involved in creating and advising police departments on use of force and other policies. We were very fortunate to have her on this committee. Professor Amy Donahue from UConn, Professor James McCabe from Sacred Heart, Chief Patrick Ridenour from Danbury, Chief Ronell Higgins from Yale, Chief Jim Villadero from Newtown, Chief Rick Fox, also a member of the bar and former colonel of the Connecticut State Police and current chief of Enfield, was on the committee, and Mike Lombardo.
And did the committee have a legal advisor?
I think they had 4 attorneys on there, and I think that they were pretty well set in that area in terms of legal standards and interpretation of case law.
Well, I'm a little concerned about your last textual ask. You wanted clarification. You wanted the insertion of the word unreasonable to clarify the standard that an officer has to employ. I would think that one would want the same standard with the Graham v. Connor situation. And it seemed that your position on the two were a little not the same. Why wouldn't we want clarification on Graham v. Connor? And I believe you said you would hope that the court would look to those cases.
And that's a good question. Let me just clarify, because I'm under the assumption that we are talking about the same standard, because the definition that we have and that we're guided by. And so I'm assuming that we are all in agreement, and perhaps we're not, that for the definition of objectively reasonable, we'll rely on those rulings and those opinions by the Supreme Court, the same ones that we've operated on since 1985 and 1989. And so I don't see a distinction. I do see that there are additional requirements added to objectively reasonable under this bill in the including but not limited to part. But I believe we're talking about the same thing.
Was it not, I mean, through this language, essentially, we're creating a state cause of action.
Criminal liability.
Well, criminal liability, it's a state cause of action. It's not guided by federal law. So for a state court to employ a standard, that standard, if not clear, doesn't have to follow Graham v. Connor if the language isn't in there. So that was a 1983 case, right? It was a civil rights violation.
Okay, 1983, sure.
And this language creates a different cause of action, correct?
So I can't answer that, but I would hope that we take this opportunity to get on the legislative record exactly what the Judiciary Committee means by that, because if the intent is to depart from the only definition that we have and seek a new interpretation by the court in the first test case, then that concerns me. But
yeah, by not including that language, in my opinion, you're jeopardizing every officer that's on the street to make that determination whether or not a judge in the future is going to follow Graham v. Connor. And that's why I'm saying that language should be included. In fact, sir, have you had the opportunity to review the other written testimony that's been submitted with regard to this bill 6462?
I have not, but I have spoken to many people over several months. Some opinions I agree with, some I don't.
Well, one of the individuals happens to claim that they're a police officer.
Rep. Fishbein, I'm just gently going to remind everyone, because it happened a couple of times so far, to let the individual, both participants, let the individual finish their statement and then ask the question.
Sure, thank you. Sir, were you done with what you had to say?
So what I was saying is that I don't necessarily agree with that. And I've been doing this for a long time. My goal here is, and I want everyone to know that I'm looking, and my goal as I get into the latter parts of my career is to make sure that people stay safe. But I am also here to make sure police officers stay safe, and not just physically safe. And I want to make sure that we do provide them with language and with guidance so they don't make poor decisions. And so I don't agree with everything that people are saying. I understand and I respect their point, but I would also hope that we have the opportunity here to get on the record, because is it safe to say, and sir, I know that you're an attorney, but would it be safe to say that the courts may rely on the legislative intent of this committee when you craft this legislation? And it would be helpful to know if that was the intent of this legislation, to depart from Graham v. Connor, or is it the intent to develop language consistent with Connor, again, but for the additions of the including but not limited to scenario that's present in the bill?
Well, sir, I would offer to you that if the committee debates whether or not to include the language, and the committee makes statements as to the effect of not including the language, and then the committee ultimately approves the language without that insertion, that the pitfalls and the perils that the committee discussed perhaps would be apparent. So, that's the concern. And there is written testimony submitted by an individual who claims to be a police officer and a police supervisor, who also indicates that this language should be cleared up. And this is an individual who's apparently out on the street, is actually faced with these things. And that's why it's of concern to me, because I too would like to have clear rules as much as possible, so that, all parties concerned can operate on a level playing field. So, I thank you, sir, for your testimony. I'm still a little puzzled as to why this language is not in here, but I look forward to the future discussions. Thank you, and thank you, Mr. Chairman.
Thank you.
Thank you, Representative Fishbein. Representative Porter.
Thank you, Mr. Chair, and thank you, Chief Mello, for your testimony this morning. A couple of questions, just for clarification for myself. With the first request that you're making in line 16, I believe it is. I'm gonna pull up the document. You want to change exhausted to considered. Can you just tell us, please, what the difference is in both, in defining them? Exhausted versus considered. How is that going to impact the language, and what exactly is it that you're looking to do? That's what I'm trying to understand.
Certainly, and thank you for the question.
You're welcome.
When we look at the word exhausted, it's ambiguous in the sense that it creates an expectation in the minds of police officers, and this was a significant concern they had, that there's an expectation that they must, as I said earlier, move from one alternative to the next, even if that alternative is a lesser response that is disproportionate and is ineffective, but that they may be required to engage in that lesser alternative, even though they know through their training and experience, with those conditions that are present to them at that time, that those may be ineffective. Are they going to be criminally liable because they didn't use a lesser and disproportionate technique? And so we thought that it's important that as they go through this quick decision-making model in seconds often, and they look at the situation, they assess the situation, they reassess the situation, and they make a determination as to what force is necessary and what force is proportional, that they've at least considered those options and have decided that those options are not reasonable and are not proportional. And so the concern is that there will be a criminal liability and an expectation in 2020 hindsight, as we were talking about here on the Graham case, and that expectation would be, that there would be an expectation that they engage in those behaviors or those responses. And that the concern is that they'll be placed at risk, and the concern is that they will be unnecessarily criminally charged, when in fact they should go to the proportional response.
So I think the question that prompts is, what if they don't? I mean, because you're talking about in real time, right? It's been stated. This is not hindsight. This is not 2020 vision
Right.
that they're dealing with. So what happens if they don't have the time to give consideration, right? I think there's a difference in actually considering something and exhausting something. When you talk about exhausting, there has to be some thought that's given. Is that not correct?
So perhaps we're talking about the same thing. And I think this just illustrates the ambiguity of the term, because to me and to us, and we've talked this over with ourselves and with the committee, the word considered means that I've given it its due. And I thought about it and I said, no, I can't, this is not proportional. Exhausted means that I have tried this. And that's where the ambiguity comes in. So if we're having trouble, you and I, and reaching a consensus, think about the officer in the field. And so when we say thoughtful and careful consideration, that officer has to articulate, when the question inevitably is going to be asked, why this response and not that response? And the officer is going to have to articulate, because that wasn't proportional, because I didn't deem that to be effective or be effective, because this is how things took place at the time. And so I think we're talking about the same thing, but again, that ambiguity puts in the mind of police officers that if I don't use something that's lesser and potentially ineffective, I may be criminally charged. And so we're just asking for clarity on that.
Yeah, and I think as we discussed it's clear to me that I don't think, I can't say that changing this from exhausted considered actually remedies that. Exhausted means that you've done it and it didn't work. Considered means you thought about it, but you might not have necessarily taken that option, when that option might have been an option you should have taken. But I'm going to move on to ask you the same question about the substantial versus reasonable. I mean, unreasonable.
Mm-hmm. So when we think of substantial is, again, anytime that you use force, there's a substantial risk. Especially when using a firearm, which is often how police officers use deadly force.
Mm-hmm.
If you miss your target, there's a substantial risk to people that that are in that area, that live in that area. It is a dangerous, dangerous business, and it is extremely messy. And so there are times, and I hate to deal with hypotheticals, but I'll use one just to illustrate and apologize in advance because I hate to use hypotheticals. But think of the person that has now you're trying to arrest and they're escaping, and they are they've committed an egregious act. An evaluation has to be made. Do I let that person go? Because if I shoot at that person, if I stop that person who may likely kill or harm others, and there are homes in the area, there are cars in the street. It's almost the functional equivalent of saying, in most cases, do not use force, do not use deadly force because of the concern of where that's going to go. And that's ever-present danger. And so what is unreasonable? And on balance, if somebody is that much of a threat to society and has committed such an egregious act and you're trying to arrest that person or prevent them escaping with the intent that they may kill or harm, whenever you use force, most ever when you use force, others are going to be at risk. I can think of two situations, or one particular that I was involved in, and it was a very, very difficult decision. I didn't use deadly force because there were too many people around, but had I used it, I would have been certainly justified, as this person was firing 3 shots at me from 10 feet away. I could hear the bullets going by. This is a residential neighborhood. Those bullets, if I miss, were going to go somewhere. It is just a dangerous, dangerous situation whenever you're firing a firearm. And so we felt unreasonable. Again, on the balance, was a better way to judge that.
And I think the thing that concerns me with all of this, and well, I'll hold that statement because I do want to ask you about changing a deadly weapon to a dangerous instrument. That definitely concerns me. Could a cell phone be considered a dangerous instrument?
Well, if you look at the definition, I would say no. I would say it's very, very unlikely because when it says any instrument, article, or substance in which, when used or attempted to use, capable of causing death or serious physical injury. So the question would be, and certainly be for the court and for the prosecutor or what will be the IG, the question is, can a cell phone kill you? But a bat can kill you, and a pipe can kill you. And we know that we've had assaults and we've had homicides where people have had their heads bashed in with baseball bats and with pipes and those kind of things. And so I think when you ask the question of a cell phone, it seems to me very, very unlikely. So we're not talking about somebody believing a cell phone is a gun. That's not what we're talking about. We're talking about whether that person had that weapon or that instrument. And there were some, as we discussed this and we debated this, of whether deadly weapon was implied, that the Judiciary Committee believed or assumed that they were talking about the same thing. Because if we're going to protect police officers and the public from those people that are carrying knives and guns, wouldn't the same apply to those that are carrying baseball bats and pipes that are being used to kill or to seriously harm others?
That's a good question. I think the thing that comes to mind now, we'll get off the cell phone. If you're in a school, right, a pencil is considered a writing instrument, but a pencil could be considered, we could leave open the opportunity for an officer to say, I thought that he might use the pencil to hurt me. I'm just putting it out there because I'm concerned about who's making the decision, and I think there's a lot of wiggle room when we talk about unreasonable and then changing deadly weapons to a dangerous instrument. And the last thing that I'll say is that, I know it does represent a change in training, but I want us to be mindful that this law was enacted due to the disproportionate use of force in communities of color, especially deadly force. So when you talk about police officers and public and safety, let's remember, we want the public, you know, to feel like they're being protected as well, because there's no doubt about it. And we have great officers, and I just feel like this always needs to be said, because when we talk about these things, people take offense. I have family, friends, they're police officers. They're great police officers. New Haven, Hamden, officers that I've dealt with, great police officers, but there are exceptions to all these rules. And police brutality is real. And that is what this was birthed out of. Let's not forget what happened to George Floyd. I mean, we just had an incident down here in New Haven where a person was being punched in the head and kicked them, you know, just in an effort to be arrested. And it calls into question excessive force and excessive use of force, and when that is needed and when that's not needed, and the disproportionate use of that force on Black and brown bodies. So I'm listening to you. I'm taking all things that you're saying into consideration, but I hope that you're giving me the same courtesy as I express to you the concerns that I have around what I'm seeing is wordplay. And I'm really trying to understand, you know, the significance and the meaning behind changing these words. So, I mean, if there's anything you want to say in response to that, I welcome that. And Mr. Chair, I'll go ahead and thank you for the time.
Sure, I do. And just to go back to your first point, again, it's important to remember when we're talking about the dangerous instrument that it is already present in our criminal statutes and our assault statutes. And I also would remind you that you've put in place an inspector general that is going to be, the IG is going to be making those determinations. And so that should bring a higher level of confidence when those things are being evaluated. And then I'd like to respond, and I agree with what you're saying, and there's no disagreement between anything you and I are saying, but words matter, and the clarity of those words matter. And it's important because police officers are going to be out there in the field, and it's important that we can train them and provide clarity in that training and be able to answer those questions ourselves. Remember, I'm here talking to you. I've done this for a very long time, and I've been in the weeds in this for many years. I've watched what's going on around the country in use of force. I watched in California change their use of force bill and put the word necessary in there. And by the way, they got $30 million from the legislature for training as well, which would be was kind of nice. But you could see this coming. We've been talking about this for years. When we started this work, and also there are police departments that have more restricted use of force policies than your statute, than the state statute, because they started to recognize the need. And then finally, the reason we're here and the reason we're looking at this and the reason that we put this committee in place on June 6th of last year was the disproportionate treatment and was the things that we see on videotapes and we see a couple things, right? As we look at it from the police lens, like you would in whatever discipline you're in, you see things differently. But we look at it through a police lens. We look at it and we can see and we believe in our own 2020 hindsight of issues where there were clear violations of a law and violations of the oath. And it was criminal behavior. And we can see others where we look at it and think, okay, that was probably legal, but it wasn't necessary. And so it's probably a little easier to focus and to manage those that are illegal because everyone knows they're illegal. But it's that gray area where police officers may use force when it wasn't absolutely necessary. And that's really what we're trying to focus on, to try to fix that and correct that. And so if you look at our policy, Representative Porter, we've done the work, and that's what's going to guide police officers. That's what is going to guide police officers towards the equity that we all seek. And the training program, the policy is only as good as the training program. I would offer that it's more important than the statute because that's what police officers are going to remember. So your point is well taken.
Thank you. And I'll add real quick that the training is important, but I think it's what's in the hearts and minds of people that is even more important. And that's really where this comes from. You know, you treat people the way you want to be treated. That has not been the experience of Black and brown folks when it comes to police interaction. And I'm speaking as someone that has been a victim myself. And that's why I'm expressing these concerns, because this raises red flags. And you did mention that, you know, the judgment is in the hands of a higher level of confidence when we talk about the AG. I feel that to be true. So that is why I'm also struggling with why it's necessary to change these words when we have him in place to make the judgment on this. Thank you, Mr. Chair.
Thank you, Reporter Representative Fiorello.
Thank you, Mr. Chairman. Thank you, Chief Mello. I think we all definitely strive for a safer society, and we all here look for win-wins where we are safer, the community is more confident in the policing, and police officers are confident in their ability to do their jobs. And I wonder if you could comment on, we're meeting here today because this part of the legislation goes into effect in a few weeks. And if the suggestions that you're making aren't passed and the legislation is enacted as voted in the summertime, what will we see, or what are your concerns then in terms of what will happen in April?
Good question. Thank you. We're not ready. This was a heavy lift. And if you had the opportunity to listen in on any of the calls from this committee that I just spoke about, I mean, these are academics and experts in this field and trainers in this field, and they worked on this continuously, and debated every single, because words matter, right? And especially when you're out there and you're making decisions using, that involve life and death and involve like criminal liability as well. And so that's how long it took them to do that work. And so to expect us to do this on October 1st, I think, again, I refer to what I said in my statement. Remember, police officers have been trained under that single standard for the most part since 1985, and then again in 1989. And while there's been improvements and some evolution, especially in the areas of de-escalation and diffusion, they're trained in that every year. This is a significant change. We can do this, and some of this is already being done. It's an easier lift for some agencies more than others, but it has to be developed in policy, because that's what's going to guide officers. They need specificity. I could put you in a simulation format and you would realize how difficult these decisions are. But if we have a right to expect that police officers make the best decision possible, and quite frankly, better decisions. And so let's take the time. The policy is there. We now have to develop a training program. We're developing for the first time a training program that is going to be the minimum standard for every police officer in the state of Connecticut. We can do that through the post council. I think one of the issues before is we had different training protocols and methods in different parts in different departments. We're going to insist upon simulation in real life scenarios. And one of the things we did in 2019 at the post council is we didn't have the ability to mandate this, but we had strongly encouraged that any time that you teach a use of force related subject, whether it be firearms, whether it be use of force, whether it be less than lethal or taser, it needs to begin with a component of de-escalation and mitigation. And that the culture needs to be that the absence of force is really the success. And so now we have all the right people at the table to do this, but it takes time. So in summary, we're not ready. I don't know. I don't know what police officers will do. They'll have to adhere. Some are ready. Some have already done this, but they will have to abide by the law.
And you say that the training will be substantially different from the way they've been trained in the decades thus far. Can you sort of help us understand what would be so substantially different? And are there other states where they have sort of gone this path and so we can benefit from their knowledge and experience? Or is Connecticut sort of first in having to retrain our entire police force?
So I'm not using the term substantially different. So I apologize if I said that, but it will be different in the terms of using, insisting upon scenario-based training and simulation type training, which is something that is very difficult for some agencies, especially small agencies. There's agencies that have benefit of simulators. This is very expensive equipment. But we're going to insist upon that every police officer be trained under the same set of guidelines to a minimum. And there are very different levels of policing throughout the country. There's different levels of training for recruit training. There's very different levels of in-service training. And I know that many of you on this committee have probably done a Google search and looked at that and seen that. However, there are some good models out there. Baltimore has a really good model. And we're looking at that and trying to use some of these agencies that, especially those that have already had federal oversight, as a model for their training program and how that fits with us here in Connecticut. But we're talking about not just creating a training program, we're talking about creating a training program around some new guidelines, which is makes it even a little harder. But we can do it, we will do it. I think you'll be proud, all of you will be proud of the work that, I hope you've looked at the policy. I hope you're proud of that. We are, and I think you'll be proud of the work that we do in terms of use of force. And at the end of the day, it'll be the outcomes that'll determine how effective it is.
Thank you, Chief Mello. Thank you, Mr. Chairman.
Thank you, Representative. Representative Blumenthal.
Thank you, Mr. Chair, and thank you, Chief Mello, for your service to Milford and to the state, and for your testimony today. I'll try to keep my questions relatively brief, as I think we've covered a lot of important ground through some of my fellow legislators. I couldn't help but notice when you were talking with Representative Porter, there seems to be kind of a little attention in kinds of the way you're coming at the issue of considering versus exhausting. And would it be fair to say, from your perspective, that the problem with the word exhaust comes from the idea, perhaps, that it will be interpreted that the officer actually has to have taken the action that's on that escalation of force up to deadly force, rather than just merely considered it and rejected it?
That's correct.
And of course, sometimes you don't have time to actually take the action of the lower level of force.
That's correct.
But at the same time, I've heard throughout your testimony that you believe that when we're looking at the actions of officers in deadly force and perhaps excessive force incidents, we should always be making sure that their conduct is objectively reasonable. Is that fair to say?
That's correct.
And so it seems to me that one way to perhaps reconcile the tension that we were kind of hearing between you and Representative Porter, you seem to be kind of talking about the same thing. Would it be fair to say, would it accomplish the same objectives for you if the language, instead of saying merely considered, it was considered and reasonably rejected a lower level of force?
That would be fine. I think it's the equivalent of what we're looking for.
Okay, so it sounds like that standard of objective reasonableness is the most important thing throughout, and that's I appreciate you clarifying that. And would you agree also? Do you think it's important to consider all the actions in a use of force incident, all the actions of the officer, not merely the exact moment that the force is used?
I do, and that's a good question, and thank you for asking that, because I'd like to comment on that. Some of the language, some of the things that you put in the bill, the factors including but not limited to, those are factors that we often see in policy and we should see in policy. And so when we train police officers, we train them on all these things that they should look for as a threat assessment, because we go through these threat assessment models, right? And so those are all important factors to be considered. And so the difference with what we're doing, so we agree with the inclusion of those. The difference is you've included those in the statute, and now there's a criminal liability, and there's also a criminal liability for, but not limited to, which is an unknown. So we will disagree that whether it belonged in the criminal statute, but we will certainly agree that it's relevant to every use of force situation, and it should be considered and evaluated by police officers when they make these decisions. Okay,
thank you, Chief. And who who decides what is going to be reasonable in these circumstances?
Well, that would be the court. Ultimately, that's the court.
Would it be fair to say also that you and the council and everyone in charge of creating policies, rules, tactics, techniques, and procedures for departments, would those, all those standards, would they also be relevant in your mind, or should they be relevant?
Well, they are, because we're the authority for training and to develop standards. And, we've created some very, very restrictive standards from going beyond what you've asked for as a legislature in terms of de-escalation and, in terms of decertification and some other areas. And I think this all goes hand in hand. And so, yeah, that is, we do seek legal advice, and we don't always agree, but certainly before we're going to look at language, we want to make sure that the words are chosen carefully.
Thank you, Chief, for that answer. I think this will be my last question. I think one concern that animates some of the questions we've heard from Representative Porter and perhaps others has to do with the idea that not only, I think most people would agree that an officer's conduct should be judged not only based on what they actually subjectively knew, but also what they should have known at the time. Would you agree that that is important to consider as well?
Well, I certainly think it's important that it be judged based upon what they know. But what you're asking me is what they should have known and what they reasonably should have known. And so when you look at Graham v. Connor, it talks about what a reasonable police officer would have known or how they would have acted at the time, not what that officer believed, or it's what a reasonable police officer. And the reason I believe that it says police officer is we are in this unique situation. I've been there twice. And I've had a knife stab into my leg, and the only thing I remember is the warmness of the blood filling up in my thigh, and had a fight to subdue this person. I probably made some mistakes, but I did the best I could with the information I had. I never saw it coming. When somebody shot at me and fired 3 shots at myself and my partner, I never saw it coming. I wasn't even sure later who fired the shots. And I saw the gun go in the person's hand, the gun being handed to someone else. It takes time for those things to register. It is very, very difficult under these very stressful conditions. The information we have is 100% of the time wrong. It's never complete. So I don't know, when you ask me the question of what they should have known, who's making that evaluation? Are we looking at it frame by frame and saying, well, the officer should have known that? That really speaks in contrast to Graham when it talks about 20/20 hindsight and the danger of doing that. And I don't think that that's fair to the officer, because that's not possible in real life.
Thanks, Chief. I think just to kind of sum up my perspective on things, I agree that it's important to have an objective reasonableness standard for kind of every step of an interaction. And I think you can't judge objective reasonableness by what a person didn't know, and there's no reason for them to know. I think at the same time, a lot of people are concerned that if we get too subjective in that standard about what the person actually knew, then you can have a situation where somebody will seek to justify their actions after the fact by essentially claiming ignorance of something. And it's incredibly hard, as you know, to prove subjective intent. So I would say just in general that I agree with you. I think objective reasonableness is a really important standard. I would think that we need to look at not only what an officer actually knew in the moment, but also perhaps what things that he or she perceived in the situation, how that should have affected them. But I agree that at bottom, we really, we shouldn't be judging people by what they can't possibly, what they didn't know and can't have known. So I appreciate all your testimony and your perspective and your service to your city and to the state. And thank you, Mr. Chair.
Thank you.
Thank you, Representative Dubetsky.
Thank you, Mr. Chairman, and thank you for coming in. I apologize, I'm not able to get my video working on my phone, so I present you with a facsimile of my face. You had mentioned a couple of things that I just wanted to ask you about. One is you talked about Graham v. Connor, and that you believed that a court would sort of read into the statute the holding of that case and the theories of that case. And you and my question to you is that how do you know that the court would do that?
Well, Representative Dubitsky, I don't know that. And that's why I use the word that I assume. And I would hope that is that the Judiciary Committee in passing this legislation or moving this legislation forward, talking about the Public Act, that it wasn't the intent to depart from that. Because I think that presents, some serious issues. While I certainly understand in the previous question answer that with Representative Blumenthal, the concerns that he has, I recognize that, and I think we should recognize that.
Okay, because my concern would be that when the state legislature deliberately removes language that follows the standard set forth in Graham v. Connor, I would think the court would be required to interpret that as the state departing from that standard. And I don't think that once that was eliminated from the statute, I can't imagine that a court could read it back in. Do you have any comment on that?
I don't. I appreciate your analysis and your opinion on that, and that certainly does raise some concerns. What would be the criteria that? And if I could ask you a question, sir, if you don't mind.
Sure.
What would be the criteria that the court would use to judge whether something was objectively reasonable if they don't rely on Graham?
That's a good question. I can't answer that, and I don't think anybody can. And my concern is that that your officers on the street who are being faced with somebody who is potentially attacking them wouldn't know either. It would leave it ambiguous, and the last thing we want is for a cop standing on the street trying to protect himself and others to not really know what the standard is. So that was one of my concerns about removing that language in the first place. But I do want to go on to another issue with regard to the proposed change from exhausted to considered in line 16. Mm-hmm. When I read that, my thought was police officer standing in a room like a restaurant, and somebody starts charging them with a knife. That police officer now has multiple ways to address that threat on his body. He's got presumably a taser, perhaps some pepper spray, maybe even a baton and a firearm. And it seemed to me that using the word exhausted would require the officer to attempt to employ each of those in order before getting to the firearm, where seem that wouldn't make sense to try to kind of run through all of your devices when the one that you know is going to be effective to prevent the person from stabbing you, or you hope it is the firearm. Is that the theory behind changing it from exhausted to considered?
It is.
Okay, so the officer considered whether or not the taser would be effective, considered whether or not the pepper spray would be effective, and determined in that split second that the only way to save his or her life is to go to the firearm.
That's correct.
Okay. All right. Well, I appreciate your responses. Thank you for coming in. And thank you, Mr. Chair.
Thank you.
Thank you, Representative. Senator Champagne.
Thank you. Chief, couple questions, and I want to touch base on the exhausted as well. Can you tell me what the 21-foot rule is?
I can't, because I'm not something that, I mean, the 21-foot rule is a rule that had been established that's saying if you're within a certain distance and you pose a threat, say with a knife or other deadly weapon or dangerous instrument, that you'll likely be successful in harming somebody or killing somebody. I've also read enough about it to say that it's not valid, and there's other considerations that need to be taken into account, that it shouldn't be if this happens, that happens. And in fact, that's one of the things I think we need to get away from, is if this occurs, then that can't occur. I think that's void of the objective analysis that needs to take place.
Have you ever gone into a situation with where you actually tried that, where somebody with a knife ran at you and you had to pull your weapon and fire a paint round?
No.
You haven't? Okay, I have. I've done it outside. I've done it in a building. I've done it given different scenarios. And obviously what we try to do is get an object in between you and the person.
I'm sorry,
Because
so
that's
did you say a paint round like in simulation?
Right.
I'm sorry, yes, I have.
Okay. And so you have done it.
In training, yeah.
Okay. How many times were you successful at stopping the person coming at you in the 21-foot?
With a paint round, never.
Right. Because 21 feet, when somebody's coming at you with 21 feet, you have to pull your weapon and you have to fire a round accurately. And within 21 feet, they're going to get to you and they're going to stab you. And that's why we trained basically by putting an object in between you, whether it's a car or something. So when we talk about exhausted, in certain situations, you have no choice. And so I like what you, I like your wording. Obviously, I think we can go a little further with that. The substantial risk or of injury to a third party. Mm-hmm. You also put unreasonable. You show up at a scene, we were talking about this yesterday. You show up at a scene where somebody is at a Wendy's and they're shooting the place up. You know from the radio call 6 people have died. The suspect is running towards a McDonald's now. You can naturally assume that he's probably going to go in there and do the same thing, correct?
Yeah, it's probably make a logical assumption, certainly. Okay,
so, but I can't stop him, because if I shoot at him, I'm shooting towards the McDonald's and there's people in there. That's why I think when we talk about substantial and unreasonable, I like unreasonable risk, because at that point, I think you really need to stop that person from getting into that building, and you don't want to hurt anybody, but you really need to do something to stop them. And you also made the recommendation for a dangerous instrument, which I also agree with. I've been hit with chairs. I've been hit with many different things, especially at domestics, where you're not expecting it. Conduct of a police officer, if we don't put unreasonable, does a situation, if a police officer shows up at a scene in uniform, in his marked police car, does it escalate the situation?
I think it does. I think certainly the presence of a police officer is going to, increase some concerns that something is going to happen.
Right. And moving to make the arrest of the suspect or a relative.
Of course.
Yep. Just questioning. Same thing.
Right.
Or even a second officer showing up.
Mhm.
I mean, all these things where we say any conduct of the police officer without putting unreasonable in there, basically somebody can claim all of those. So I agree with you on that as well. So I do want to thank you. And as far as the training goes, if we can't get everybody through the training, how can you hold this new law accountable against anybody? So I like the changes you're proposing, and I'm going to vote for this simply because of just these minor changes and the fact that we do need to push this off to make sure that we train all officers in the state. Thank you.
Thank you, Senator.
Thank you, Senator Champagne. Are there questions from other members of the committee? Representative Staffstrom.
Thank you, Mr. Chair, and thank you, Chief Mello, for being with us and for all your work on this. I want to go back a little bit to last summer and some of the discussions we had and kind of what led us here today. I think it's fair to say and probably unquestionable that even with these proposed changes, these proposed language modifications that we're discussing today, that this legislature in the state has certainly shown a willingness and a desire to strengthen the legal framework that governs police use of force in Connecticut. Do you agree with that statement?
I do. I agree.
Okay, so even making these proposed changes, we have raised the bar from where we were before last summer.
Representative Stafford, I would be comfortable saying it's the most restrictive use of force policy in the country, and I think that our policy will does reflect those changes, and I think the fact that we're here today, maintaining the original intent but asking for clarity, I think also shows that we respect those changes that you voted on last year.
Okay, I just wanted to make sure because my audio cut out a tiny bit there. So it's your belief that even if we make these proposed changes here today, even if we pass House Bill 6462, that Connecticut will still have the most restrictive use of force policy in the nation?
Yes.
Okay. Correct. Chief, with that, I want to publicly thank you because we had this discussion last summer. Mm-hmm. The reason the use of force policy doesn't go into effect until April 1st is predominantly a factor of your commitment to me and to others who were proponents of the police reform we did last summer, to call together a group of the best legal minds and experts post could find to look at what the most restrictive use of force policy would be for the state, and one that would withstand legal scrutiny. I think it's not an insignificant concern to consider if someone is charged with this. Unfortunately, if an officer is unfortunately charged with a criminal violation for unauthorized use of force, that policy would stand legal scrutiny. And I think, in my mind, you and the Post Council were true to your word that you gave us last summer, that you would look closely at the statutory language we put in place last year, that you would not come back and ask for us to repeal it or water it down in significant ways, but would help us effectuate the intent that was to move Connecticut towards a strengthened legal framework for use of force policy. And I want to thank you for that. Chief, let me just ask you briefly, actually before I do, so on the, we've talked a lot about kind of the words, but talk to me about this mandated training policy a little bit.
Sure.
How did that come about, and what are the next steps, whether we pass this bill before us today or not?
Certainly. So the policy was approved, was completed by November and was approved in December by the Post Council. And so the next step, we have now put together a group of, using the original group, we've expanded it to include use of force trainers. We've included Attorney Elliot Spector, Attorney Eric Daigle, who are probably the two primary authorities on training and do a lot of training nationally within the state. We've included them. We brought in those use of force trainers that are in the field doing this training. We want their expertise. We want buy-in, certainly. And we want to then translate the policy and the law into an effective training program. What are the best ways to train? And what's important is, and that's why I started, even though I know it was lengthy, talking about how we see the world of use of force. And so that's an important mindset that we need to start with police officers. And so the idea is to use scenario-based training and to use real-life cases and to provide a decision-making model based upon clear guidance so that they can go out there and produce better outcomes. That committee will debate and develop goals and objectives. They will develop content, and they will develop lesson plans. That will then go to the Post Council. The Post Council may send it back for additions or corrections or subtractions. And once that's approved, then that we will put as part of the CLES standard and mandate that every department in the state of Connecticut, every police officer in the state of Connecticut, use the policy as a minimum floor, a minimum standard, and use the training program as a minimum standard. They can improve on it if they want, and they can add to it. Once we train those trainers who are certified use of force trainers, then they'll go back and train everyone else. So you may see departments go beyond, but no department will be able to go below that standard.
So at the 30,000 foot level, then it's fair to say that the ultimate goal here is to make sure every police officer in the state of Connecticut is trained in what you would consider to be the most restrictive use of force policy in the nation.
Well, I think, again, going back, I think it's, in my view, it's clear that we have the most restrictive use of force policy. And but for Connecticut police officers, it's going to be easier for new officers. It's going to be harder for existing officers because they've been operating the same way for a long time. But so it's a big task, but we'll have it done by that October date.
Right. And the goal, and like I said, so the goal to that certainly is to not have to minimize as much as possible the instances in which officers would use what we would now consider to be unreasonable deadly force because they've now gone through this new training.
Right. We want to improve the outcomes. And look, we've already looked at the accountability piece, not just through here, but also through decertification and the IG's office. So it seems to me that the goals that you have and that we have are, I think we've done quite a bit to go in that direction.
Right. And I would agree with you, Chief. I think that certainly the goal, certainly my goal last summer working on that legislation was to improve outcomes. And I think the proposal here before us moves us in that direction. The last thing I just want to touch on is we've spent a bunch of time talking about the word exhausted versus the word considered. I'm wondering if the committee considered any other word other than the word considered. It seems, I guess where I'm going with this is it seems you've got kind of exhausted on one side, you've got considered on the other side.
Mhm.
And I think some of the concern I'm hearing from folks today is, considered means, okay, I thought about it. Did I do anything with it or not? Back to kind of Representative Blumenthal's point. Were there any other words that the committee kind of kicked around as potential alternatives to the word exhausted that maybe aren't quite as finite as
I understand.
exhausted, but also maybe not quite as loose as considered.
Sure. So I think Senator Blumenthal, I'm sorry, Senator Blumenthal, Representative Blumenthal, I'm sorry, I apologize, Representative Blumenthal. I thought that his suggestion has merit. I would ask you to ask that question of CPCA when they're next, because they dug into that very deeply. They may have.
Okay, I will, because I mean, one of the words I was kind of just sitting here thinking is the word weighed as opposed to considered, because weighed means you've actually kind of evaluated pro versus con as opposed to, yeah, I thought about it. But I'll be sure to ask them. Chief, again, thanks for your work on this. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative Stafstrom. Representative Rabembis.
Thank you, Mr. Chairman. Just a few points of clarification. Good morning, Chief. How are you?
Good morning.
Thank you again for the work, and I want to echo the sentiments that's been said by many of the members as to the intent of these proposals, which is to make the public, but as well as our law enforcement officials, safe in the requests and duties and responsibilities we have asked of them in order to keep our communities safe. With that, Chief Mello, the original proposal that's led to the legislation that's currently obviously before us being discussed, you had concerns regarding the original proposed language. Is that correct?
That's correct.
And after the legislation was passed, there has still been concerns, and evidently those concerns have even raised to the point of this new proposal. Is that correct?
That's correct.
Okay. So Chief Mello, did you at any time over the summer, before or after the legislation passed, ever make a representation or a promise to someone that you wouldn't come back to ask for changes of language?
No, I never did that.
Okay. I didn't think so. Certainly I wasn't privy, but I thought I'd give you the opportunity then to respond to that. I think based on all of the testimony and questions I've heard here today, there is definitely some clarity that is required in this legislation. I would also state that the fact that no court is required to consider legislative language, we've actually had a Supreme Court justice before us indicate the same in that regard. So as much as we would like to create a record and rely on that, there is no tying of hands to that effect. And I do think that once we are making changes to language, we need to be careful that our true intent, if it's to keep with the law, that it is then reflected and clarified in the proposal before us.
I agree.
The other thing I'm sorry.
If I, Representative Rabembis, if I could just make a comment on what you had just asked. So I want to be clear, and I don't think I was, how we came here. So post-council did their work and had this use of force committee. And they looked at some things that they saw some infirmities in the language. At the same time, I had finished my term as the CPCA president, and CPCA had their own committee, and they were looking at that. And so they provided suggestions, as did we. We reconciled that. So we are here, and I think when you speak to Chief Mclanson and Chief Asaro and Chief Sampson, who are, I believe, going on very shortly, they'll explain that to you. So that's why we're here. There was never any type of deal made with anyone, because we also must respect the fact that this passed, and so we realize that it is going to be difficult to get some of these changes. And so we are looking at things that we think need to be clarified. And so we did make a decision not to come in and ask for substantive changes. But that wasn't as a result of any type of a deal or agreement or anything else.
Sure, and Chief Mello, to your point, and that's why I wanted to clarify, because it gave the insinuation that there was some kind of promise that changes, and I quote, changes to the language and or watering down wasn't going to be requested, and I certainly was not privy to any of that. And because that was in the line of questioning to you, I wanted to clarify with you if that was your recollection or any promises were made. And it clearly, many conversations were had, including an open debate, that there was a lot of concerns, hence the date of the April for its effective date, which would allow us time to correct it, which and it's my personal opinion and humble position that legislation should never pass knowing that there's corrections that need to be made to it, because again, people are affected, the community, officers, training, et cetera, are affected as a result of that. So I don't think that that serves anybody well in that regard as well. But thank you again for your testimony. Thank you, Mr. Chairman.
Thank you.
Thank you. Rep. Stafford again.
Thank you, Mr. Chair. Mr. Chair, I just have to clarify. Certainly, I was not trying to, despite the implication, give any sort of suggestion that there was a deal. I think what I was trying to imply is that this committee would be open to reasonable tweaks to the language based on the training protocol that was promulgated. That has always been my intent, and in fact, the reason we're having this hearing here today is because of that assurance to be open-minded on reasonable tweaks that did not undercut the substance of the law we passed last year, but did provide clarity and the necessary time needed for training. I just wanted to make sure that was clear, Mr. Chairman.
Thank you, Rep. Staffstrom. Rep. Fishbein.
Thank you, Mr. Chairman. Chief Mello, I just want to bring you back to the language for a moment that we were talking about. We've talked about objective, subjective, and we talked about the dangerous instrument aspect. And once again, you know, you had mentioned that you would hope that a court would employ the statutory definition, but you would agree with me that there is no link back to a statute in the language before us. So just suggesting if you'd be in favor of you know, reference to 53A3 so as to take away that uncertainty with regard to what a dangerous instrument is.
I would, Representative Fishbein, and that's in my written testimony, that dangerous instrument as defined by 53A3, and to include that statute in the in that dangerous instrument within the language.
Yeah, I just didn't remember that portion of your testimony. So I think that would be helpful. So thank you, and thank you, Mr. Chairman.
Thank you.
Thank you, Representative Fishbein. And thank you, Chief Mello, for joining us this morning. I just want to express appreciation for the work you've done, not only today, but in the lead up to the bill to help us to understand some of the concerns that you had, and would just suggest that during the debate on the floor, it was suggested that there were concerns about the bill. And I don't think we passed a bill that people felt was doing something that didn't work, but we're open to having a conversation because people who've done legislation recognize that that's the best way to make things happen. And so that's the reason that we're sitting here today, to consider what it is you have to say and what others have to say. And I think out of this, you know, we wind up with legislation that potentially improves upon what we did. I will suggest that the conversation with Representative Porter, followed up by Representative Blumenthal, and thinking together about ways to address both concerns actually could improve upon something that I think was an improvement upon the way that we were doing business as a whole. So thank you for joining us this morning. We ate up a little bit of your time, but I think you now are free to enjoy the rest of your day. And we'll be happy to see you the next time you visit us.
Thank you, everyone. Enjoy.
All right, have a great day.
Thank you, you too.
Next, we will hear from Paul Mclanson from the Connecticut Police Chiefs Association.
Hi, good morning or afternoon, Senator Winfield, Representative
Good morning.
Saxton, Senator Kissel, Representative Fishbein, distinguished members of the Judiciary Committee. My name is Paul Mclanson, and I'm the Chief of Police in Farmington and have been since 2009. I am joined here by Chief L.J. Fazaro from Grotontown and Chief Scott Sansom from East Hartford. We are here to speak on behalf of the Connecticut Police Chiefs Association in support of House Bill 6462, an act concerning use of force by a peace officer, which makes some very important modifications to Section 29 of Public Act 20-1. I think Chief Mello did a great job explaining the necessity of these changes in order to clarify the intent of the legislature and allow our use of force policy and training to be consistent and standardized in our state. Unlike in television or on the movies where our favorite police actors and actresses are routinely involved in shootouts, thankfully, the great majority of police officers will never discharge their firearm in the course of their duties. This does not negate the fact that every officer must be ready to do so if found in a life and death situation where it's necessary for the protection of themselves or others. The changes proposed are necessary since an officer needs to process this law in a split second with potentially deadly consequences. Unfortunately, they are not afforded the luxury of additional legal opinions, court decisions prior to acting. Therefore, the intent and application of the law needs to be trainable and logical for our officers. I believe that these changes will allow for that. Thank you for your time, and we welcome any questions.
Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Chief Mclanson. Nice to see you again. You were perhaps on for Chief Mello's testimony and a lot of discussion about the Graham versus Connor situation. And did the chiefs, the body that you sit here today representing, have any position with regard to whether or not it would be appropriate to insert the language clarifying that the officer is supposed to employ the knowledge known to him at that time to this language?
So the Graham v. Connor objectively reasonable language, and I think it's a, I guess it's a mea culpa. We've had many conversations with many chiefs, many officers, many use of force instructors and experts. And to my fault, I understood the objectively reasonable in here to mean that. And I think, because in law enforcement, since 1989, when we talk objectively reasonable in the use of force, we always cite Graham v. Connor. It's in every test we have, because that was the standard that created in use of force what was considered objectively reasonable. So to your point, I think it's important to get the intent of the legislature. And again, it's mea culpa on me. I assume that that's what we were talking about. So I'm glad that it was brought up here for you to discuss, because again, I think that it is important because our officers, that's the standard they know. If we went to a different objectively reasonable standard, I'm not sure what cases we would be able to refer to in a theoretical what is now objectively reasonable and be judged upon that. I hope that answered your question.
Yeah, and that's exactly the problem, the way I see it, because there are no cases, and we would be starting fresh here with regard to a different standard that is unclear, and it wouldn't be the legislature making that determination. It would be the judicial branch because of the void of the language. So, I appreciate you addressing that and recognizing that perhaps something needs to be done there. And I thank you, sir.
Thank you, Representative. Further questions from the committee? Chief, just a quick one. I see a couple of the hands, but Chief, just a quick one. If you could comment on, if you recall the question I asked Chief Mello, which he so politely punted to you on whether words other than the word considered were considered to replace the word exhausted. Something like the word weighed or Representative Blumenthal's suggestion. Is there something in between the two words that was that you looked at?
So we did not, and I would say that really the major difference and listening to the, to many of you speak, I think the one thing that we thought was exhausted kind of referenced the physical application, and that's what we were in looking at a policy when they said exhausted. It's I think we looked at it in the legislation saying that, does that mean, and that was the question, does that mean that we have to try it first? And when we wanted to do consider, we thought that that was more a mental exercise, that you should be going into something thinking about what is the least amount of force, what is my best tactic that I can possibly use, what can I do? So it was more that mental aspect of things. And I will say in use of force, and to Chief Mello's comment about us doing simulation, that is one of the things that we need to do, because the minute that we are presented with a use of force, you don't want the officer then to think this is a brand new thing, I have no idea what to do, right? It's something that in training, we've seen a variable of it, we've seen something like it, and we've already considered these things. And maybe not to be exact. So that's why we thought that considered meant, listen, we want you thinking about alternatives. Obviously, we thought exhausted kind of referred to the fact, again, with that person with the knife or somebody pulls a gun on you, do I need to try and use my spray? Do I need to try and use a baton? Then I can move to my gun, which obviously I think we all recognize that would be, I wouldn't be able to get any of those done. So I'm willing to, I think that there's probably some better suggestions than considered from you, but I think we were more the intent of it, of that you need to go through these mental exercises to put yourself in a position to use the least amount of force as necessary. And that is reasonable under those circumstances. And so that's why we just kind of use considered rather than exhausted.
Okay. But I guess what I hear you saying is certainly depending on the word choice that you and perhaps the association are not necessarily wedded to the word considered, but if there's some other word that maybe has a better, maybe poses better that you've thought about and then ruled out other possible options that you could be open to some other word other than considered.
Absolutely, we would be open to other language, and I think really it's going to come down to the intent of the language, because it's going to come down to how we train the officers in that language, right? So if you said Wade, we're going to go through, and obviously with your intent of what you wanted that to do, in the training with the officers. To give meaning to that word, right? Like, and what your intent with that word was. But yes, we would be open. Short answer.
Thank you. Representative Callahan.
Thank you, Mr. Chairman. Thank you, Chief, and your colleagues for being here this morning. In preparation for today's public hearing, I tried to read as much material as possible, as I'm sure many of my colleagues have. One of the pieces of material I read, Chief, after the accountability bill went into was passed, did retirements or go up, or and recruitments go down?
So I can speak personally that our retirements did not go up. However, our recruitments went significantly down. So that I can only speak for ourselves. I'll let.
I think in response to that, it varies per department. I've heard of some departments that did experience losses through retirement and other attrition. Recruitment has been a challenge even prior to this bill, but I will say I think we're experiencing that across the board. All of our departments, I think it's safe to say, has really revamped its efforts for targeting minority recruitment and minority hiring. Yet we have seen an impact of that. So I think it's fair to say that it's been varied across the board, that all agencies, some more so than others, have experienced some impact. Whether it's real or perceived is yet to be seen, but we've seen something happen. Yes.
Thank you, sir. Articles I've read show that recruitment's down as much as 70%. And I'm sure my colleagues here, and I am a freshman legislator, but I am quite interested in making sure that we help get the best police officers in Connecticut, not hinder that process. In your opinion, gentlemen, would 6462 help or hinder that process?
I think it would help. I think our position right now is this is taking the legislation that was passed last summer and improving upon it. And I think that this would, I know it would certainly help our existing officers who, quite frankly, are one of our best recruitment tools. They find other people that they encounter out in the public that they feel would make good police officers. And I think this would help give them a better understanding of what the legislature wants our police officers doing and make it, as my colleagues have said, easier to train and understandable by the police officers themselves.
I concur. I think it would absolutely help.
Yeah, absolutely. As we get trained up and as we understand the policy and as that spreads through the media and social media and things of that nature, then individuals that want to be police officers will start taking new understanding that there's a new expectation set for police officers. We've gone through many changes over the years, since the 30s and 40s, and even since all of us have about 30 years experience here or more. And, things over the years, we police a lot differently. So I think that's when it settles down. I think this new legislation, the new wording will allow us to do that, so we can have better training programs, policy, and officers to be able to understand it and get back to doing our jobs. And right now, there's a big level of discomfort because we really don't know what this is going to look like or what it's going to mean. But I lost at least 3 or 4 that retired fairly abruptly due to the accountability, and my recruitment's been okay. To keep on recruiting up, but it's definitely going to help us.
Thank you, gentlemen. If you're finished, I don't want to cut you off. I certainly appreciate you coming in today, and I'm thoroughly impressed with the questions from my colleagues on the committee. Everyone clearly has the best intention, and if we can help you by passing 6462, I hope that'll go through. Thank you. Thank you, Mr. Chairman.
Representative Howard.
Thank you, Mr. Chairman. Good morning, gentlemen. Chief Mclanson, I just first want to say, regarding Graham v. Connor, it's not so much a mea culpa, Chief. That's exactly what this process is for. There are a lot of moving parts to a lot of legislation, but specifically this one, and that's what we're here to do, is sort of flush all those things out, because as you try to get, and you can see the debate over a single word, how that goes. I've been trained for years in Graham v. Connor, sir, and my recollection is that the objective reasonableness as it pertained to there and was without regard to any underlying motivation, and it was objective reasonableness when you're judging a police officer's use of force under the 4th Amendment, objective rather than the substantive due process that you would in a criminal trial. So my question to you is, when Judge Rehnquist, I think it was Judge Rehnquist, delivered that decision, I think that was the holding of the court, but then he cautioned that it should be judged with objective reasonableness with the information known at the time, not with 20/20 hindsight. Is that in keeping with your training and the way you train your officers?
So, yes, it is. And I actually have the exact language I think that you're referring to that we've kind of looked at is, in quote, from the perspective of a reasonable officer on the scene. Again, it's not the officer, it's a reasonable officer on the scene, including what the officer knew at the time, but not with 20/20 vision of hindsight. I think that's what you're referring to, right? Like being able to then, what we call Monday morning quarterback, right? And go back and say, well, boy, if we had only done this, maybe we would have known that. If we had only done this, maybe we would have known that.
So
That's what you're referring to.
thank you, Chief. I appreciate that. And my concern is that when Judge Rehnquist rendered that decision, that definition of the elimination of 2020 hindsight was not necessarily included in the definition of objective reasonableness, even though we've adopted that standard and trained that way. The concern that I have, and I think some of my colleagues have, is that, and it should be noted, right, Chief, that that got to the Supreme Court because two lower courts held that officer accountable for information he didn't have, that the individual was a diabetic. That's how it got there. So to suggest that no reasonable person would hold an officer accountable for information that he only found out afterwards is just not true, because otherwise that case wouldn't have made it to the Supreme Court, right?
Yeah, and again, it's I think it's whether a reasonable officer would have or should have known that in those circumstances that were described, because there's so many different circumstances that an officer is is confronted with. So
I think that we all share, in law enforcement across Connecticut, and I've shared with some of my colleagues that police officers in general are as vested in police accountability, because I will speak for myself, having 2 decades of carried a monkey on my back of being criticized for the actions of others that I don't want anymore. So I'm all for police accountability and transparency, and I'm sure you gentlemen are too. I know one of you very personally. And what I'm driving at here is, do you feel that if we're trying to get to the goal of police accountability and transparency, do you feel that adding those few words of information known to him at the time would in any way inhibit that accountability and transparency and making sure officers are using force in an appropriate way?
So I guess each circumstance is a little bit different, right? And so depending where it was and how it was drafted, because I guess I'm not sure how that would impact the law in and of itself. As far as because every call is a little bit different, right? And so we use the reasonable officer, not the subjective belief. And that's what I think that's what we're trying to use here, is what the reasonable officer would do in those circumstances, right? And so I think everybody's understanding of what objectively reasonableness right now, every current officer's understanding, right? But now I think we're adding things to it to make it more restrictive, which I'm not opposed to. But it does need to be clear for those split-second decisions. And so I just don't know where that would fit in and how it would work out. I guess that's my question.
Well, if we look at the legislation that you're testifying about in line 12, at the very end, objectively reasonable under the circumstances, and I would suggest adding in known to that officer at the time. And if we added that, could we still reasonably hold officers accountable for misconduct?
Yes.
Okay, because that's my point, Chief, is officers need to be held accountable for the misconduct. I don't know a single reasonable person that would debate that, and it certainly would not be me. But I also think that when you consider the 2 cases, they're the 2 hearings that led to Graham v. Connor being at our U.S. Supreme Court, people will hold officers accountable for information that they didn't have. I know that, I've seen that, and I think that that's the problem. And I'm glad to hear you say that adding those words would still allow all of us to hold those officers accountable for their actions. I thank you, gentlemen, for your service and your testimony today. Thank you, Mr. Chair, for the time.
Thank you, Representative. Representative Fiorello.
Thank you, Mr. Chair. Chief, I wanted to ask you, I had a chance to go on a ride along with my police department here, and I didn't know what to expect that day. And I was quite surprised when, I was in a car barreling towards a car accident scene. And it really gave me an understanding that truly when police officers go to work, they really don't know what that day holds for them. I also I came away with the impression that actually our police officers do so much. And I wanted to ask you, understanding this new definition of use of force in the whole scheme of like all the work that police officers do, how important is use of force and understanding that clearly? Could you help us understand the scope or gravity of getting this right?
So obviously it's ingrained in everything we do. And although use of force is such a minute portion of what we do, right? When you think about, to your point, Representative, when you think about all the things a police officer does, the use of force is so minuscule in its use in most agencies. I'm not gonna, but all of us are reporting on it, and that those statistics will be out, and I can speak for my agency itself. However, the misapplication can have dire consequences. So how important is it? It is immensely important to make sure that we train it and then we carry it out the right way, because the potential consequences for not doing that can end in the loss of a life for somebody else, for the officer, or for anybody. So the importance of it is immense to make sure we get it right. But also, and Chief Mello made mention of this, that in the last several years, law enforcement has started almost, and I have started every training with, how do we get out of using force? Because once you start using force, the end result it is not a win. It's not a win for the subject, and it's not a win for the officer, right? So always we are trying to minimize our use of force. But you have to be prepared to use it, because unfortunately, there are times when it is required in order to either protect your life or others.
Okay, thank you for that. And when you have conversations with folks who come in interested in the career of being a police officer, how do they ask you about the new definition of use of force, or are you finding that recruits are concerned about the bill that passed in the summer or this particular clause? Does this come up in conversation?
So this specific clause does not. I think, with the police accountability and, listen, there's a lot of things that go on out there. I have 4 kids. They all have social media, and they want to know why dad's a murderer, et cetera, et cetera. So when you're, because that's what's being posted, right? That, all cops are bad and certain things. So when you talk about recruitment, it's some of the rhetoric, I think, that's affecting it. And I think police accountability is obviously trying to correct some of the wrongs. I'm not going to say that there are not wrongs in law enforcement. I think in Connecticut, we do a good job. Can we do better? I always say, if you don't think we can do better, then it's time to retire, right? So we can always do better, and we're going to try and do better. But I think we are way ahead of the curve in Connecticut. But I think that's what people are. It's on social media. It's on the news about what's happening in policing. And some of these instances, which are, are affecting people. And I think that they're scared to get involved in policing right now because of a lot of it.
Thank you, Chief, for your additional comments. Thank you, Mr. Chairman.
Thank you, Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony, Chief Mclanson. I don't really have any questions. Just want to, again, reiterate what I'm hoping will be the mindfulness behind and the purpose behind why this bill was necessary to start with. And I think the one thing that is clear, and I want to make sure that this is made clear again, what police has proven in Connecticut and across the United States is that reasonable is subjective depending on the zip code. We talked about words matter, but what is very evident as well is skin color matters. And I want to bring it home to Connecticut because there are so many things that have happened in this state that really do support the need for this bill. Jose Soto, fatally shot April 2nd, 2020. And that was Manchester. Edward Gendron, January 20th, 2020. Waterbury, fatally killed. Mubarak Soleimani, God rest his soul, January 15, 2020. State trooper in West Haven. Michael Gregory, January 2nd, 2020, Ansonia Police. John J. Carver, September 5th, 2019, East Hartford Police. Alfonso Saporta, July 26, 2019, Hartford Police. Anthony Vega Cruz, April 20th, Weathersfield Police. Kyron Sand, February 20th, 2019, Willimantic. Paul Arbitel, December 29th, 2018, Danbury. And I can go on and on, but I'm just trying to make the point that there was a reason for this bill. Connecticut has a problem, and it's not just Connecticut. And we have great cops, but we also have some cops that need to be held accountable. And that is the purpose of this bill. And I don't want us to lose sight of that. This is not to condemn the work that police officers in the state of Connecticut are doing. It is to bring those that are not doing what they should be doing into accountability and to provide the public, especially the Black and brown communities that have been subjected to police brutality, some transparency and some comfort and some safety in knowing that, you know, we're not going to just let officers go rogue. We're not going to let them police the way they feel they should be able to police if it's not in accordance with the way that policing is done throughout this state. And I think it's fair to say that it looks different in New Haven than it does in Willimantic or Easton or Cheshire or Manchester. I mean, like, there is a difference. And this is what we are here to address. So I want to keep that at the center. I want to keep that as our focus. And I want us to be fair, you know, and that's why I'm sitting here listening to everything that's being said this morning / afternoon around the changes that you're looking to make. But I want to make sure that everyone who this bill impacts is going to feel comfortable and can rest assured that any changes, if made, are going to improve the bill and not water it down. Thank you, Mr. Chair.
Thank you, Representative Porter. Representative Fishbein, followed by Senator Champagne.
Thank you, Mr. Chairman. Mr. Chairman, I have no questions either. I just want to, you know, I've never been a police officer, and very few of us have been police officers on this committee and in the totality of the legislature. And, you know, I'm a lawyer, I'm a state representative. When I leave home in the morning, my wife is relatively assured that I'm going to come home that night. Not so with a police officer. And one of the few jobs, you know, cops and fire, we never know what our day is gonna have. And while I have yet to meet a police officer who's in favor of police brutality, I think we're all against police brutality. We all would like to take reasonable steps to prevent that. You know, recently somebody sent me a video of an incident in West Haven where an officer was hit by a police car that had been commandeered by somebody else. That doesn't happen to legislators and lawyers. It's unfortunate. Ultimately, I think we're all here to do the right thing, but I don't come to the table in support of police brutality. And I look forward to us working on this language together for the betterment of our state. So thank you, Mr. Chairman.
Senator Champagne.
Thank you. Thank you, Chief. Or I should say Chiefs. Question. No, I've been out of police work for just over 8 years after doing 22 years. The use of force continuum, do we still use that?
No.
We don't. Do we have something the same?
When you say the same, there have been many different concepts that have come up. Instead of a use of force continuum, Sometimes they do a circle, and there's been all different things discussed. None of them are actually supported. It's more now the version is that the use of force needs to be proportional to the use of force against you. So, and the continuum, it just was a visual for officers. It never said that you had to start with verbal and then hands and then OC and then taser. It never said that, but the visual of it, kind of like the word exhausted, almost makes people think that that's what they had to do. And so that's why then they went to a circular use of force. But the training on it always is, and that's where it lies in the details, is how you use that. And it needs to be proportional to the force that's used against you and the threat.
And if you violate that new circle, what happens?
Well, you get arrested if it's and we'll say a minor violation, right? Like if somebody was overly aggressive, manhandled somebody, not to the point where it was you would get disciplined or terminated, but definitely and arrested, potentially sued.
Right. So you face consequences. Okay. And does the average person truly understand police work?
I don't truly understand being a doctor, so I would say no. I don't truly understand being a lawyer, so I would say no.
Okay. You bring
and
up
I've
an
watched a lot of doctor show and lawyer shows. I still don't really get it.
Right. Because you have to live it, because you don't understand walking into a basement with somebody who's potentially armed, or going, into a domestic and the victim attacking you from behind. Yeah, it's a tough career and very stressful for that. But I went through some questions before that I don't think I have to go through all of them again, but the unreasonable, when we talk about the conduct of the police and the change that we're asking for, the unreasonable conduct of the police under Section C, number 2, Section C. And I asked a couple questions. Did you hear those questions when I asked them before?
I'm sure I did.
Okay. Basically, they are showing up at a call increase the presence of the officer. Would that increase the tension with the suspect?
Your mere presence potentially can, yes.
Yep. Moving to arrest the suspect or a relative?
Yes.
Questioning?
Yes.
Second officer showing up?
Yes.
Okay. And when I look at this, putting the word unreasonable in there, these are the types of things I'm thinking about. And it should have went in the first time. And I, some points were made back then, but it'd be great if we could correct it here. And obviously the dangerous instruments. I said before, I've been hit by chairs. I'm sure you guys have been hit by many different things as well. And when we go back to exhausted, the reasonable alternatives to the use of deadly force. When somebody's second guessing and they look at this word exhausted, and let's take it right to the court, I think that goes pretty extreme, because I think officers are going to use the least amount of force. Every time there's a shooting across the United States, justified or not, these officers are just being brutally brutalized in the media, social media, everywhere. And no officer out there wants to shoot anybody. And I think of one incident that I had where a gentleman kidnapped his wife, had planned a suicide murder, and she actually gained the trust of him. And he stopped to get gas, but the FBI had shut off the credit cards. And needless to say, it all ended up where this guy pulled a gun, and that gun came up, was aimed at my partner. And I started to pull the trigger on him. And if it takes 4 pounds of pressure, I put 3.5 on there. And that gun came up, and he took his own life. But you don't have time. I mean, this gentleman ran, jumped in the car, pulled the gun. Everything is instantaneous. And you had brought up doctors. Doctors have a long time when we talk about patients. and they make mistakes, but I don't see people calling for their arrests. You know, they pay financially. But, you know, when you're looking at instances where it's an instantaneous situation, I mean, you know, you have to say when you use the word exhausted, that's pretty steep. Do you guys do you know what the 21-foot rule is?
Yes.
Have you gone through the simulation training with that?
Yes.
Have you ever stopped the person charging you?
No.
Yep. I mean, I haven't found many people that have. I mean, in my end training, I know we talked about keeping an object, such as a police car, in between you and that person, which gives you that little bit more time. But, you know, when you walk up and that person's within 21 feet and all of a sudden they whip out a knife, you don't have time to say, oh, should I start here? Should I start there? And, you know, I know I heard, you know, a politician once say, well, shoot him in the leg. Is that practical?
No.
No, it's not, especially when you're stressed out and fighting for your life. You know, I'm going to stop there. Thank you guys. Thank you for coming in and answering questions today.
Thank you, Senator Champagne. We have Rep. Porter, followed by Rep. Fiorello.
Thank you, Mr. Chair, and I won't take up much time. Just for the record, I don't have experience as being a police officer, but I would like to state that I do have experience of being a victim of excessive force, and in my opinion, for no good reason, other than the color of my skin. So I just want to put that on the record and just keep bringing it back to what brought us here. You know, this is the exception, not the rule that we're talking about. We're not saying all cops are bad, all cops are rogue, and all cops set out to be, you know, to brutalize Black and brown communities. But what we can say is that it is happening. And this legislation was passed to address that. Thank you, Mr. Chair.
Thank you, Representative Fiorello.
Yes, thank you very much, Mr. Chair. I wanted to ask the chiefs, is there, I think every instance of someone losing a life or being victims of crime or discrimination, you know, is terrible. But I wanted to give you a chance to speak to that. Is there any evidence or is there a sort of comment on something that Representative Porter had said? Is there evidence that our police officers, you know, is there a moment to think about race when you're in those moments where your life is, you know, in the line of your work? I just wanted to see if you had any comments on that, because I would love to understand that better as well. Thank you.
Yeah, you know, I don't want to seem naive to the fact that we all come to this with our experiences, our life experiences, our work experiences, and those sorts of things. I can't say that we don't have racist police officers in Connecticut. I can't say it. Do I hope that we absolutely don't? Yes. Will we work forever as chiefs of police and other officers? Because as you have heard from even, you know, other officers, they don't want them in our ranks. So I guess, you know, the point being, we will do everything to weed out anybody who has a bias such as that. But we all come in with our, you know, our implicit biases, those sorts of things of, you know, and it's a matter of, and sometimes they keep you alive, right? Sometimes it's a matter of something that you've experienced before, somebody reaching for a waistband that you're like, wait a second, right? That's not right. It doesn't matter whether that person, who it is. But there are, you know, I think we work very hard to make sure in policing, and obviously the accountability and, you know, the chiefs of police are definitely really attuned to making sure that any use of force is completely reviewed and then now submitted to the state for review. So I hope, I know I didn't really answer your question, but I hope that, you know, I'm not naive to think that everybody is, you know, thinks everybody else is equal.
You know, the problem we have in our profession is the same every other profession has. We have people from the human race, so they have all their frailties, all their their bias, all their experience. That is something that we have in law enforcement, clearly. But I think we're pretty good at weeding that out, and we're pretty good at making sure that when there is a violation or there's a problem, that we identify it and we address it, whether it's through training, discipline, or if need be, through the criminal system. But one thing that was brought up before about these situations is police officers go into it with those human traits and characteristics that we have, and there's language in case law that we rely on, particularly when it comes to use of force, which these often happen during times of very tense situations where the outcome is uncertain and they evolve rapidly. So it changes quickly. So there isn't one set or one script that officers need to follow in each particular case. It changes all the time. So we need police officers that aren't that are relying on their training, but are adept and intuitive enough to change based on the threat that is presented to them, without consideration as to other factors. If it's a threat, it's a threat, whether it comes from a man or a woman, whatever the race, color, creed, or condition that person is. They need to respond to that, and they need to do it in a way that's effective, that brings a successful resolution in that situation, and hopefully using the least amount of force necessary in those particular situations.
Well, thank you for every effort that you make to help us understand your line of work in today's questioning. And thank you, Mr. Chair.
Thank you, Representative Fiorello. I don't see any other questions, so I want to thank you all for joining us today. I do want to say, because there's been kind of an exchange going on, that I'm a legislator who has walked around the legislative office building and been asked many times by people why I'm so angry when I'm not angry. I've even had a smile on my face and had people ask me that question. And I want to point out that these aren't people that people might assume look at people, my skin color, and see anything other than a human being, right? We afford people certain credit and certain discredit. Those biases come into everything. And police officers and legislators and all of us carry those things with us. And some of us act upon those things in very important and sometimes deadly ways. We give police officers the ability to use force to the point of death. And what this bill that we did over the course of the summer into the fall was really about making sure that we check that force appropriately. And what we said was we were going to come back and have a conversation about the things where not just there was disagreement, but where there were important places to make sure we got it right. And I think what Representative Porter is trying to point out, and others are trying to point out here, is that part of understanding how we get it right is to understand the experience of the people for whom the bill was actually done. And that's not the experience of everyone. Not everybody experiences this the same way. I stood on the floor for 10 and a half hours and did the bill that brings us here today. And during that time, repeatedly, people kept saying to me, that's not my experience. And that's understood. But you can't say to people who have had that experience that experience isn't real. And so what I hope as we continue to go down this path is that everyone understands that we are making an actual attempt to get this right. I think the exchange with Representative Blumenthal earlier represents that. There's a way to think about this stuff. This bill, like any other bill, is a bill where we will continue to have conversations. And I hope that everybody comes to this conversation in the same way, hoping that we don't water down the bill, hoping that we make the bill better. And it would actually be stronger if we could come together and think about the things that need to be in the bill. And I want to thank the CPCA for actually engaging us at points of conversation as well, because that's important to this conversation. And I just hope that as we're going forward, everyone remembers that, because I will tell you that, like, I don't have the experience of being a police officer. Police officers don't have the experience of being a legislator. And we all experience all kinds of things, including danger. Many people know that I've been run off the road for the work that I've done, right? That's just a reality. And I think that's what Representative Porter was trying to get at. There's a reality here that's not often spoken about in the way that it should be. It doesn't negate the experience of a police officer. It doesn't negate anyone's experience, but it's important to the conversation. So I want to thank you again for joining us today and offering your perspective, because I think it's critical to the conversation. Thank you.
Thank you so much. Thank you.
is Representative Joe Barry on? I think I saw her.
Yes, I'm here.
Good morning.
Good afternoon, actually.
Afternoon.
Senator Winfield, Representative Sastrom, Senator Kissel, Representative Fishbein, and esteemed members of the Judiciary Committee. I am Jill Berry, the state representative, proudly serving Glastonbury. Thank you for raising House Bill 6462, an act concerning use of force by a peace officer, and holding this public hearing today. I am in strong support of the bill. Moving the effective date for the use of force standard to October 2022 is a needed fix to the enacted police accountability bill. It is not feasible to properly define the new standard and adequately train the approximate 9,000 state and municipal police officers before the original date of April 2021, which is a mere 38 days from today. If this goes into effect, it could affect officer safety as they may not fully understand the new standards, therefore not act accordingly, and/or there is possibility of increased liability if an officer violates the new standard unbeknownst to him or her. The slight word changes in Section 2 will have a huge impact on an officer's ability to keep our community safe. Though police reforms are needed, accountability needs to be coupled with proper resources and discretion for officers to do their job. Both are needed for our communities to thrive. It is crucial that we continue to have these conversations about the impact of the Police Accountability Bill and its effect on public safety, and that law enforcement voices are heard so that we can get a sense of how these provisions play out in the real world. Again, I want to personally thank you, the leadership of this committee, for raising this bill, and I urge all my colleagues to support it. Thank you.
Thank you, Representative. Are there questions or comments for Representative Barry? I do not see any. I want to thank you for joining us this morning / afternoon and providing us with your testimony. Have a great day.
Thank you, you too.
Next, we will hear from the Chief State's Attorney, Rich Colangelo. Oh, there you are. Good morning, good afternoon. I keep saying morning.
Good afternoon, Senator Winfield. Senator Winfield, Representative Shafston, Ranking Members Kissel and Fishbein, and members of the Judiciary Committee. Thank you for allowing me this opportunity to testify this afternoon on Senate Bill 892. Prior to the 23rd Amendment of our state constitution, judges appointed all prosecutors in the state. The legislative record in 1984 shows that the main concern of the General Assembly was to insulate state prosecutors from outside political influence. The history indicates that they chose to establish the Division of Criminal Justice and the Criminal Justice Commission through a constitutional amendment rather than statutorily, as a public defender system was established to prevent changes to the system on a political whim. The General Assembly knew in 1984 that prosecutors have to make some difficult decisions in who and how they prosecute, and political influence should have no bearing on any of those decisions. There can be no doubt that the position of Inspector General would be the most vulnerable to political pressure. That is why it's vital that this committee amend Senate Bill 892 to cure the constitutional defects that were contained in Public Act 20-1 last summer and still remain in this bill. I want to point out a few of them or highlight some of them. You have my written testimony also, the written testimony of the division, sorry. Only the commission has the constitutional authority to appoint any and every prosecutor in the state. Having the legislature appoint the nominee of the commission does not comply with the Constitution. I want to kind of ask, what if the legislature doesn't appoint the nominee of the commission? What do we do with that person? The statute allows 3 deputy chiefs, so we couldn't fill the deputy chief state's attorney to be the IG position since we have 3 already. The person that is being interviewed by the Criminal Justice Commission is being interviewed for that specific position. And now we're going to have a situation where we have somebody in that position that doesn't have a portfolio of work or anything to do in the division. Under the Constitution, the state's prosecutorial power was vested in the chief state's attorney and the state's attorneys. Every other position within the division must get their power to prosecute from either the chief state's attorney or the state's attorney of that district. That is why the 2 current deputy chief state's attorneys, pursuant to the statute, shall assist the chief state's attorney in his duties. Senate Bill 892 does not include that proviso with regard to the deputy chief state's attorney who will serve as IG. In Section 3 of the bill or proposed legislation, having a member of the Criminal Justice Commission on the State's Attorney Advisory Board is also problematic. the commission, the Constitution only gives the commission the ability to appoint attorneys as required by law. Presently, we have 2 judges, as you know, and 2 attorneys that practice criminal law on the Criminal Justice Commission. This section is ripe with conflicts and separation of power concerns that we have. Section 6, subsection J of the bill talks about staffing of the Inspector General's office. This subsection removes the proviso that prosecutors within the IG office come from within the division. As such, it suggests that the IG would have full, unabashed hiring authority without any limitations with the division or vetting of the commission. Lastly, I know that the Connecticut Association of Prosecutors provided testimony to the committee, and that their president will be speaking, but I also wanted to highlight the sections 2 and section 4 conflict with the current contracts that we have with the prosecutors union and collective bargaining. So thank you for the ability to testify here today. I should have led with this, and I'm sorry. I know we did it in our written testimony. The IG is an important office for the state and for the Division of Criminal Justice. It's going to help, foster that or gain back the trust that has been lost in the system. So we want to make sure that the individual is able to do their job in a way that's not going to be hung up in litigation or questioned in any way. Thank you.
Okay. Thank you for that. I'm gonna let Representative Fishbein ask his questions.
Thank you, Mr. Chairman. I'll be brief. Good morning, sir. I think it's still morning. No, it's afternoon. Prior to seeing this document, had anybody consulted with you about the language before us today on 892?
Yes, sir. We provided testimony to the committee.
Other than that, I'm just a little, I'm puzzled. There seems to be a lot of problems with this language, and especially the constitutional problem rises right to the top. And I'm wondering, it appears that I've looked at the written testimony that's been submitted. It appears nobody's in favor of passing this as presented. So it begs the question, where did this language come from, if you know?
I do not, sir. I'm sorry. When over the summer, when the original language was proposed, our testimony hasn't changed. These constitutional concerns are still there. And it's a situation where I don't want the position to be hung up in litigation. We want to make sure that we get it right. And that's why I'm pointing out these concerns to you.
Yeah, agreed. And, another part of your written testimony has to do with the members that are serving on the CJAB.
The Criminal Justice Advisory Board, yes, sir.
Yes, and the fact that certain members of the commission are bound by the rules of professional responsibility and other individuals are not. Can you just flesh that out? I think it's important also.
Well, the judges that sit on the commission would have inherent conflicts and potentially constitutional issues with getting involved with policy of the division, and that's one of the things that the State's Attorney Advisory Board does. The members that are criminal defense attorneys, it's difficult to say. One of the things we discuss, we discuss policy, we discuss cases, we discuss litigation strategy in those meetings. So having somebody that is representing a party that might come before one of us, it's, that's an inherent conflict of interest. So those are concerns that we wanted to make sure we pointed out.
And also you bring up the fact that not everybody is a judge or a lawyer, and the rules of professional responsibility would not apply to certain individuals on the board.
That is also true, Representative Fishbein, correct. Right now, you have all the.
Sorry, I didn't want to step in.
No, sorry.
Your floor.
Right now, we have, all the members are either judges or attorneys. There have been situations in the past where we have had non-attorneys be members of the commission. So, if a member of the commission, based on this bill right now, a non-attorney member wanted to bring somebody up for discipline, or they could, and they wouldn't be bound by the rules of professional responsibility that attorneys are. That was something else we wanted to point out.
So just to flesh that out, you have a member of the board that's a layperson, so to speak. And then you have another member of the board who's a judge. They have equal power on the board, but they're held to different standards. Is that fair to say?
Yes, sir.
So if a judge did something, there's a procedure, you make a complaint to the judicial branch about the judge doing something that is in violation of their canons of conduct. And similarly with an attorney, you could file a grievance or something like that. Whereas with a lay person who sits on the board, one doesn't have that remedy. Is that fair to say?
That's correct.
Okay. And how would you, if you had the magic wand, how would you solve that problem?
The problem with the State Attorney Advisory Board?
Yes, sir.
Keep it as it is constituted right now and not put a member of the commission on.
Okay, thank you. That's all I had. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Representative Staffstrom.
Thank you, Mr. Chair. Thank you, State's Attorney Colangelo, for being with us. Appreciate it. Your written testimony and also here today, you've indicated you support the creation of the Office of the Inspector General and recognize how important that office is and how vital it is to restoring trust that when a police officer is investigated and prosecuted for using unlawful force, that investigation is done free of outside influence or coercion from potentially other law enforcement units and agencies, correct?
Yes.
Okay. So you talked about in your testimony about ensuring that the selection of the Inspector General is free from outside influence, or the selection of prosecutors is free from outside political influence. But I guess my concern, and we've been down this road several times, as you know, is that if the Inspector General is selected solely by the commission, particularly where in an instance like we're facing now, where you have a deadlocked commission, you have a 3-3 vote, and someone needs to break the tie and select one candidate or the other, what level of confidence should and can the general public have that that selection is free of outside influence if that selection is not blessed or approved by some body that's responsible to the public at large?
Well, the commission is responsible to the public at large since they are nominated by the governor and approved by the legislature. So that is that should be part of the answer. It is the commission because they have the blessing. They're approved by the legislature. So having that second legislative approval, I don't believe it meets constitutional muster.
But if you think about the situation we're faced with right now, right? This is not hypothetical, where you have a commission that interviews a series of candidates. Half the commission decides we like candidate A. Half the commission decides we like candidate B. We can't change the makeup of the commission without a constitutional amendment. how would you propose that we break, that a tie be broken in that instance? Would it be you who breaks that tie?
Absolutely not. I don't believe that if there was no if the legislative approval wasn't part of the statute and the commission knew that they had to make a decision, I believe they would have made a decision based on the interviews that they did back when they interviewed for this position. I mean, they selected a chief state's attorney. They select deputy chief state's attorneys. They come to a conclusion on these positions they have since they've been established.
Right,
Without
I didn't mean to cut you off. Go ahead.
No, sorry.
That's were you a part of the discussions this past fall about the selection of Inspector General?
No, sir. I sat in on the interviews, didn't ask any questions, did not participate in the executive session. Historically, that's the way it works for deputy chiefs.
Then how can you be so confident that, but for legislative approval, that the commission would have decided on someone if you weren't party to those discussions?
Intuition, sir. Just knowing the commission, they've done it for every chief state's attorney and every deputy chief state's attorney that we've had. They've been able to do it. The one where there's legislative approval on, they deadlocked.
I guess my fear and my concern is if we're trying to create an office of the Inspector General that is free from influence by other states' attorneys, by members of law enforcement, and is going to be held out to the public as truly independent in these decisions, having the same folks have the same level of authority over selecting the Inspector General as selecting any other prosecutor doesn't provide that additional level of assurance, doesn't provide that additional level of accountability or independence than in the selection of any other state's attorney.
One of the issues I think that we also run into with the new version, or with 892, sorry, is, as you know, over the summer, the Attorney General issued an informal opinion pursuant to a request last year before the bill was voted on. In that opinion, he stated that the Inspector General would have to be nominated by the Commission from a pool of professionals previously appointed by the Commission. For that reason, the legislature appointment of the Inspector General is an action subsequent to the Commission's original appointment and would not appear to be a significant interference with the Commission's constitutional prerogative. We're changing that in this situation also. So I understand conceptually, I understand what you're saying. I really do. And I understand the public confidence, and that's really what's important here. But I think, we have to abide by the Constitution. Anything that we do that's not, I fear that the Inspector General is going to be tied up in anything they try to do. It's going to be tied up in litigation before they can do anything.
But you keep saying like it's some established fact that there is some sort of constitutional defect with the with whoever the commission selects as the Inspector General, them nominating, and then a final confirmation by this committee, by the Judiciary Committee. You're saying it is established fact that is some sort of constitutional violation. The language you just quoted from the Attorney General suggests otherwise.
Well, in his language, he indicates that as long as it's somebody that's previously been approved by the commission, and this new rendition of the Inspector General statute now includes the ability to go outside somebody. So you could potentially hire somebody that has not been previously approved by the commission. So that's what I'm looking at his language and the plain meaning of that.
Okay, so maybe he hasn't weighed in on this exact language before us here today, but on a previous iteration, he seemed to go the other way. But irrespective of that, I guess what I'm getting to is, how can you be so confident as to sit here and say there is absolutely a constitutional defect? Because as I read the Constitution, the commission shall appoint state's attorneys, right? We're not changing that. We're not saying that the legislature is gonna weigh in on who the state's attorney for for the Fairfield Judicial District is. And then there's the and such other attorneys as prescribed by law. The important piece to that is as prescribed by law. So the commission's authority to appoint other prosecutors is as prescribed by law, the way I read the Constitution. And it sounds like, at least under an earlier version of this bill, the Attorney General seems to read it the same way I do.
You had asked, how am I so confident? We are lucky in the Division of Criminal Justice to have some of the greatest appellate attorneys in the state. I have had them or asked them to do an analysis of this, and they are telling me that this is what they believe the situation will happen. I mean, what they're finding. So that's where it's coming from. As prescribed by law, if they're appointed by, and in the rendition of the bill that sits before you right now, the commission is nominating and you are appointing. So they are not appointing that individual. You're usurping that. The bill usurps their authority to appoint. They're nominating in your situation, and then you are appointing. That's why I'm saying, or I believe, that there is a constitutional infirmity to the statute.
I guess I read it differently, particularly on that, and part of the reason, this committee was sent 2 names of potential inspector generals last fall. And part of the reason we took no further action with respect to that is I don't think it's appropriate for us to select from 2 nominees. The commission's job is to send us a nominee and say, this is the person, this is who should be the inspector general. And then what we have prescribed in law is that nominee, that selection, we give a thumbs up or thumbs down to, but we don't get to pick. We don't do the hiring. We don't go out and interview or take resumes. Frankly, it's not that different than what we do with judges, workers' comp commissioners, or any other number of appointments of folks within the judicial system. They are selected, vetted by somebody else, and then come to us for an up or down vote.
I understand. And in your example, what happens if you give it a thumbs down? That person's been selected by the commission for the particular position. And what do we do?
The commission needs to send us another name.
What do I do with the person that was first selected? They've been selected. And actually, if you look at the statute, the commission really can't send you another name because we have a 3rd deputy chief already, because that's the position that person was selected for.
Then maybe the way to rectify the language then is to put in place language that says if the Judiciary Committee votes down the nominee, then what will happen to that person? If they're already within the division, maybe they go back to the previous job they had. If they're not in the division, then the commission seeks to find them a spot someplace else. I think there's a way to do that without saying the entire process is constitutionally defective. If the concern is you're going to have an extra body that you didn't previously anticipate having.
That's not the concern. I don't want it to seem that way. And as you indicated when you started questioning, we've talked about this a lot, and I guess we agree to disagree on it. I believe that there's any legislative approval would usurp the commission's constitutional power.
Okay. Thank you, Mr. Chair.
Thank you, Representative Stafford. Representative Rabembis.
Thank you, Mr. Chairman. Thank you for your testimony. I just wanted to, because I do know that we have new members of this committee, there has also been a time that recommendations have been made to the Judiciary Committee and no vote has been taken. So I just wanted to add that to the record. So in addition to a voting down by the legislative body, there was a time that there was no vote taken by the legislative body. So I just wanted to make sure that that was clear as well. Thank you.
Thank you, Representative Rabembis. Representative Howard.
Thank you, Mr. Chairman. Mr. Colangelo, good afternoon, sir. Thank you for being here. Prior to the enactment of this bill under 51277A, who investigated police use of force when somebody died?
A state's attorney in the judicial district other than where the use of force occurred, sir.
Who was that state's attorney work for?
The Division of Criminal Justice.
And ultimately you, right? Were there under your supervision? Is that a better question?
Yeah, I mean, the division is, I hesitate because the division is made up of the chief state's attorney and the state's attorney for each judicial district. We're each independent constitutional officers. But ultimately, yes, they report up to the chief. I have very little authority over state's attorneys.
Have you had opportunity to review investigations done by those individuals who are investigating those uses of force?
I have actually done them myself, and now that I've been sitting here, I review them since the reports go out under the chief's auspices. So they're reviewed by myself.
And Mr. Colangelo, when those investigations are done, they're extensive, are they not?
Absolutely, yes.
And is it fair to say that oftentimes information is developed in the course of that investigation subsequent to the incident that the officer was not available to that officer at the time?
Yes, sir.
And that could go two ways, couldn't it? I mean, there could be information that comes about afterwards that an officer may try to use to justify his actions that he didn't have then, or information could come up that make his decision unjustifiable, but he didn't have it at the time. That can go in either direction. Is that right?
Correct.
Okay. So in the course of that investigation, and I'm not sure if you've heard earlier testimony, my big concern with this legislation is that we need to add those words to make sure that these officers and their actions are being judged based on information available at the time in either direction.
Representative, in listening to the prior testimony and being part of post-council, I agree with the proposed legislation. I think the changes are important to allow officers to understand better what the standard they're going to be held to. And by putting it out till the October of 2022 date, it'll allow them to get properly trained in it. And it'll also allow the Inspector General to get into their position before the changes are made to their analysis.
Thank you. Do you agree with me that officers should be held accountable for the information available to them at the time when they made the decision?
Yes, sir.
Thank you,
That's
sir.
the standard that's the standard of Graham Connor.
Correct, which we're attempting to codify here, basically, right?
Yes, sir.
Thank you, sir. I appreciate your time.
Thank you.
Mr. Chairman.
Thank you, Representative Howard. I would just suggest to members, if because of what just happened here, if someone who can testify to something else, and you're going to ask them a question about a different bill, just indicate, because he indicated he was testifying on 892, just so that they don't lose track of where we are.
Thank you, sir. I apologize for that.
No problem. Just want to make sure that everybody's clear where we are. Representative Doucette.
Thank you, Mr. Chair, and thank you, State's Attorney Colangelo. A question just for clarification here, and perhaps it's right in front of me, but the effective date of this provision for the Inspector General is under current law is what?
It passed, sir.
So in other words, we do not have an Inspector General who has been appointed thus yet. But my question is, so a use of force investigation that were to pertain to an incident that occurred today or last month, what would be the procedure for that? Would we be operating under the old statutory procedure, or would we be sort of in limbo waiting for the Inspector General to be appointed?
No, because we didn't have an Inspector General in place, we've had, unfortunately, more than we'd like to see of those situations occur. And we've just been proceeding under the statutory scheme that's in effect, or that was in effect before, or would be still in effect, I guess, until the Inspector General takes their position. So
okay.
I'm assigning those to a State's Attorney outside the judicial district. We are investigating the use of force resulting in death or not death. A use of deadly force, sorry, resulting in death or not death.
So in your opinion, there's no ambiguity as to those investigations that are happening today or would happen prior to any clarifying legislation being adopted?
I don't think there could. I mean, we have to investigate these, and if we waited, I think we're not doing anybody a service. So that's why we proceeded along the route that we did, sir.
Okay. I mean, I think it highlights the importance of this. Certainly, we want to try to find a a solution to this that is, everyone agrees is workable. But, you know, I think this provision of the legislation, you know, of course, depending on who you talk to, is one of the least controversial and perhaps one of the most important provisions of the law that passed. So to see it in this sort of state of limbo is a little concerning, and I think highlights the interest in us acting quickly here. And also, you know, I represent a community in my district which had a recent incident, and it was subject of a recent use of force report that is of Jose Soto. And there was a strong interest in the community in having that case reviewed elsewhere, or perhaps even by the Inspector General, which may not be clearly contemplated under this law, but I think would be something that would probably be well served in that case. Would it be your opinion that the Inspector General, once appointed and established, could not go back and re-review a case in which a report has already been issued?
It would be, sir, yes, because that investigation is completed. It was looked at based on the use of force policy, procedures, and that we need that at the time. So I don't believe going back would be appropriate.
Okay, that's all. Thank you.
Thank you.
Thank you, Representative. I'd seen Rep. Fishbein. Did you put your hand down, or Representative Fishbein?
Yes, sir. Rep. Doucette sort of addressed what I was getting at. So thank you, sir.
Okay. Thank you, Rep. Fishbein. Are there questions from other members of the committee? Seeing none, thank you for joining us, Attorney Colangelo.
Thank you.
I'm sure we'll have a lot more conversation.
Thank you.
Next, we'll hear from Kelly Moore, followed by Florencio Cotto, followed by Charles Stango. I see Kelly Moore. You may begin your testimony.
Thank you, Senator Winfield. Senator Winfield, Representative Staffstrom, distinguished members of the Judiciary Committee. My name is Kelly McConney Moore. I'm the Interim Senior Policy Counsel for the ACLU of Connecticut. I'm here to testify in opposition to Senate Bill 892 and suggest some changes. I also want to let you know that we did submit testimony opposing House Bill 6462. I won't be speaking about that right now, but I'm happy to answer questions about it. First, I want to make it really clear that we appreciate deeply the commitment this committee has shown to getting the structure of the Office of Inspector General right, so that a new Inspector General can be appointed and begin to conduct meaningful investigations into police violence. I also really want to highlight that this bill contains significant improvements over the version that was passed as a part of Public Act 20-1. First, this bill accomplishes one of the most important considerations for appointing an independent Inspector General, that is, ensuring that the best candidate, regardless of their employment background, is appointed. By removing the restriction that the Inspector General must come from within the Division of Criminal Justice, this bill clears a path for an Inspector General who is committed to accountability when appropriate. The need for removing the prosecutor-only limitation was made clear when the Criminal Justice Commission, tasked with identifying and nominating an Inspector General, only had 2 internal applicants for the position. We fully support this change. We also support changes to the process of other prosecutorial appointments, including granting the Criminal Justice Commission the ability to recommend removal of the prosecutors it's responsible for appointing. Despite these positives, this bill contains a potential problem that must be addressed before we can support it. According to Article 23 of the Connecticut Constitution, the Criminal Justice Commission is solely responsible for appointing states' attorneys and other prosecuting attorneys. We're concerned that following the process laid out in Public Act 20-1, kept in place by this bill, could lead a court to conclude that the legislature, not the Criminal Justice Commission, would ultimately be appointing the Inspector General. This leaves any nominee who would ultimately be appointed up for challenge, with anyone unhappy with how the Inspector General is pursuing accountability either too fully or not fully enough. We believe that the Inspector General must be appointed with speed and clarity. And changing this bill to make the Criminal Justice Commission solely responsible for appointing the Inspector General would give clarity. The Criminal Justice Commission has this constitutional power. That's pretty clear because it solely appoints the other deputy chief state's attorneys. In addition, we asked this committee to reconsider Section 1B8 of the bill, which provides that the chief state's attorney shall be the tiebreaker if the Criminal Justice Commission deadlocks in the nomination of the inspector general. We're concerned that this would put the chief state's attorney in a deciding position when the chief state's attorney is not supposed to be responsible for choosing an inspector general in any way. We also worry that having the chief state's attorney break ties creates bias or the appearance of it. We urge the committee to select a different tie-breaking process. Overall, we want the inspector general to be appointed successfully and to have the tools to be truly independent so that the ultimate appointee can succeed. We believe all the stakeholders want that. In our view, the changes we've outlined today would be the best path to achieving that. And with those changes, we would be very happy to support this bill and the important steps forward it contains. Until such time, though, unfortunately, we do oppose Senate Bill 892. Thank you.
Thank you. Are there questions or comments from members of the committee? Representative Stavstrom.
Thank you, Mr. Chair, and thank you, Ms. Moore, for being with us and for your testimony. I won't rehash what is my my belief that this legislation is constitutionally compliant based on under Article 23. But what I do want to ask you is, if we were to credit that, right, and if we were to take out the legislative approval piece to this, and were to take out the chief state's attorney as the tie-breaking vote, which frankly is something I agree with, we should take that out if the legislature is not going to be involved in the process. How do you propose we break a tie in the instance where you've got two candidates? One's got the support of 3 people, one's got the support of 3 people. Or I could see a situation where the commission interviews a bunch of external candidates and everybody's got their favorite. Nobody wants to, nobody gets a second vote, so to speak. How do you propose in that instance we break a deadlock vote while also assuring that that individual truly is independent and responsive?
Thanks for the question. And first, I want to make clear on the constitutional question. I'm not affirmatively saying that the bill as written is unconstitutional. What I'm trying to say is that I think there is a significant risk that it could be interpreted that way. It could go your way too, Representative Stavstrom. And so the reason we're here taking this position is for the clarity, not because we're firmly coming down on the side of unconstitutionality. With that said, I do think that a role for the legislature isn't entirely foreclosed under the Constitution. For example, I would not endorse this under any way that it's written, but I can see a situation where the legislature has more of a veto power over an appointee, where they're not doing a confirmation that may comply with the Constitution. So there, like I said, there may be a role for the legislature that would not have raised as significant a problem with the Constitution or create so much murkiness.
But isn't that what we have? Isn't that what we have under this bill? I mean, it's not, we're not saying the legislature is going to go out and interview and select a candidate and appoint that person. It's not, Chairman Winfield and I aren't going to go out and hire the person, right? It's a matter of no different than a judicial nomination that comes from the governor or a workers' comp commissioner or any other, frankly, we do dozens of these every year where, we get a nomination, our choice is confirm or not to confirm. We don't get to select the person. We don't get to go back and say, no, hire Joe Smith instead. We basically have a veto power over the selection made by generally the governor in those instances.
Mm-hmm. I will say, in talking to people who are maybe more expert on the Constitution in Connecticut than I am, there is some concern over the actual terminology used in the bill too. So, I mean, potentially cleaning that up could help ameliorate the problem, making it clear who has the appointment power, since that is the language of Article 23. And to just close the loop on your original question, I think if we need to put a tie-breaking mechanism in place. I think that it needs to be a voting member of the Criminal Justice Commission. The Chief State's Attorney is not a voting member on matters of that Inspector General nominee, which is the basis of our objection to that being the tiebreaker.
So you would basically give the chair the ability to break the tie?
Yeah, I think that that's probably the right thing. I do agree with the Chief State's Attorney that if we have a process that puts forward more nominees, I see it as less likely, not more likely, to have deadlocks in the future. The Chief State's Attorney's point that this hasn't happened in state's attorneys nominations, I think is one that I agree with. And I think that if we widen the pool a little bit, this is not going to be an ongoing problem.
Aren't you, the chair of the Criminal Justice Commission, actually all the members, but particularly the chair serves at the pleasure of the governor, correct?
That's right.
So effectively, if you give the governor's appointment basically a vote and a half to break a tie, effectively what you're advocating for by taking out any sort of legislative review is you're advocating for the governor to basically be allowed to select the Inspector General through his or her nominees to the Criminal Justice Commission.
I agree that there are serious concerns with that. Unfortunately, based on the way I think that I and others I've spoken to read Article 23, I think that's what is contemplated in the legislative history and in the language of that article, is that is a function of the Criminal Justice Commission as an executive branch board body.
Yeah, I guess I'm like I said, I'm happy to sharpen the pencil and continue to look at the language, but it just strikes me as somewhat concerning or running counter to what we're trying to accomplish here with an independent Inspector General, to have the governor have so much power over the selection of that individual. But
I do agree with that. I think that that's an important consideration, because I think that we've testified repeatedly over the summer and now in favor of the Inspector General. We think it's a very important piece to actually achieving accountability in the instances when police use deadly force. We've seen over the years in Connecticut that there are multiple factors that are blocking accountability from happening right now, two of which are before this committee today: the use of force standard and the way that investigations and prosecutions are conducted. So I appreciate very much, Representative Staffstrom, that all these changes are coming from a place of wanting to make the most effective Inspector General possible. And like I said, there are a lot of good things in this bill that we applaud, and we stand ready to be helpful in any way possible to move forward in a way that creates clarity in the process so that the Inspector General can get to work and hit the ground running.
Thank you, Mr. Chair.
Thank you, Representative Staffstrom. Senator Kissel.
Yeah, this is probably going to sound, ignorant, but why can't we just turn this council from 6 to 7?
I, right off the bat, do not think that is, hold on a second. I'm not recalling off the top of my head any constitutional limitation to doing that. Let me say that.
So we could do that.
I'm going to throw it to Representative Staffstrom, who indicated he wanted to speak.
Thank you, Mr. Chair. Just for clarity, so we don't go down this rabbit hole, the Article 23 of the Constitution does very clearly say that the commission shall be comprised of the Chief State's Attorney and 6 members appointed by the governor. So we can't change the makeup of the commission. It says the commission shall appoint the chiefs shall appoint the state's attorneys and other attorneys as prescribed by law. I think the prescribed by law piece is what gives us the ability to amend and weigh in on how the commission does its deliberations, but we can't change the makeup of the commission.
Well, we could if we changed the Constitution. It would take a couple of years, right?
Well,
can
if that's
always-
directed at me, then yes, that's.
No, we can always change the Constitution. It takes a couple of votes, takes a couple of years. But we could if we wanted to go in that direction. I just wanted to know, that's all.
Thank you, Senator Kissel.
Thank you, Mr. Chair.
Are there other comments or questions for? I don't see any. Therefore, thank you, Kelly, for joining us and adding your perspective to the public hearing.
Thank you.
We will now hear from Florencio Cotto, followed by Charles Stango, and then Brian Anderson. Is Florencio Cotto here? Oh, I see you. Okay, you may begin your testimony.
Good afternoon, Chairman Winfield, Chairman Stafstrom, Senator Kissel, Representative Fishbein, members of the Judiciary Committee. My name is Florencio Cotto. I'm a police officer in the city of New Haven and president of the New Haven Police Union. I am also the president of the Police Officers Association of Connecticut, or POAC. POAC is a statewide association of municipal police unions from large cities and small towns. I'm here in that capacity today, representing over 4,000 police officers from Berlin, Bristol, Cheshire, Cromwell, Danbury, Greenwich, Hartford, Manchester, Milford, New Haven, Newtown, Naugatuck, Prospect, South Windsor, Southington, Stamford, Suffield, Waterbury, and West Hartford, as well as AFSCME Council 4's Public Safety Chapter. On behalf of those police officers, we strongly urge you to pass HB 6462. The changes made to the use of force statute and Public Act 20-1 of the July special session are significant. The law adds new requirements for police officers in the use of deadly force. This bill will extend the effective date of that section of the bill. The extension of this effective date is critical to allow police officers to be able to be fully trained. It is imperative for the safety of our officers as well as the crime victims. The effective date should be extended out far enough to ensure that every officer is trained before they are held to a new standard. Thank you for your consideration. We urge your support. Thank you.
Thank you, Mr. Cotto. Are there questions or comments from members of the committee? I do not see any. That being the case, I want to thank you for joining us today to offer your perspective on the bill. Thank you.
Thank you, sir.
Charles, I see Charles Stango. You may begin your testimony.
Thank you. Chairman Winfield, Chairman Stafstrom, members of the Judiciary Committee, my name is Charles M. Stango. And for the last 23 years, I've been a prosecutor working within the Division of Criminal Justice. I'm speaking to you today because I'm currently the president of the Connecticut Association of Prosecutors, commonly known as CAP, a collective bargaining unit consisting of nearly 220 hardworking career prosecutors who day by day, docket by docket, and case by case work tirelessly on behalf of the citizens of Connecticut. I have had the ability to review the written testimony submitted by the Division of Criminal Justice with regard to Raise Bill 892. And a short time ago, I viewed the live testimony of Chief State's Attorney Colangelo with regard to this bill. In an effort to streamline my remarks today, I will say that CAP is in full agreement with that testimony and shares the DCJ's concerns about the constitutional viability of the Office of the Inspector General as set forth in this bill. With that being said, I, in my role as CAP president, want to point out some of our specific concerns with regard to Raise Bill 892. Issues regarding employee discipline and employee evaluation are mandatory subjects of collective bargaining under the State Employee Relations Act, commonly known as SERA. To that end, these issues have been collectively bargained and are set forth in CAP's collective bargaining agreement with the DCJ. Article 13 of this contract covers all issues regarding employee discipline. Article 11 covers employee service ratings, and Article 12 covers employee personnel files. It is CAP's position that any issues relating to changes in the manner in which CAP members are to be disciplined or evaluated need to be collectively bargained and not unilaterally imposed upon us by this body. Any attempt to impose changes in this fashion would be a violation of SERA, as well as the Contracts Clause of the United States Constitution. To be more specific, every unionized state employee has negotiated a process by which he or she may have his or her discipline reviewed for just cause, arbitrated. These include the Assistant Attorney Generals, public defenders, healthcare workers, DOT workers. In fact, Arbitration is even available to UConn sports coaches. Section 2B and C of this proposed bill seeks to amend Connecticut General Statute 51-278B in a manner that would impose unilateral changes in the manner in which CAP members can be disciplined. CAP would like to point out that Appendix A of our collective bargaining agreement states that Article 13 of this agreement, the article dealing with employee discipline, supersedes General Statutes 51-278B, and therefore, at this point, does not apply to our members. Even so, CAP is concerned with the changes being proposed as to how a referral for discipline can be originated and the deletion of a maximum amount of days that can an unpaid leave can cover. The concern is the potential to inject political influence into what should be a completely apolitical process. Section 4 of the proposed bill seeks to amend Connecticut General Statutes 51-280 in a manner which unilaterally imposes a process where CAP members' employee evaluations contained in their personnel files and governed by Articles 11 and 12 of our collective bargaining agreement can be made public to members of the Criminal Justice Commission as part of their evaluation of the non-unionized members of the DCJ, namely our state's attorneys, our chief state's attorney, and our deputy chief state's attorneys. A CAP member's performance evaluation is intended only as a tool to evaluate, promote, discipline, educate, or terminate the individual prosecutor for whom the evaluation is prepared. There's no language in Article 11 or 12 of CAP's agreement with the DCJ that would allow these evaluations to be weaponized against our state's attorneys, chief state's attorney, or deputy. Yes.
Yep. If you could summarize, because you're past the 3 minutes.
Yes, I am just about there. In light of these issues I have mentioned today, and that CAP has more fully set forth in its submitted written testimony, CAP urges this fine committee to reconsider the sections of this proposed bill in an effort to avoid running afoul of SARA, the Contracts Clause of the U.S. Constitution, and the negotiated and ratified agreement between CAP and the DCJ. I thank this committee for affording CAP this opportunity to provide input on this bill and would be happy to provide any additional information that you may request during the legislative process. Once again, thanks for allowing me to address you today.
Thank you, Senator Kissel.
Yeah, hi, welcome. Good afternoon. I'm just wondering, we went through some battles regarding the CBAC agreement. Does your unionized contract fall under CBAC, or is it separate?
The CBAC agreement is an agreement with the coalition of bargaining units that covers predominantly healthcare benefits and pension. All of the bargaining units have individual agreements with their management, with their agencies. In our case, ours is the Division of Criminal Justice. So there are two separate agreements. There is the individual unit agreement with their agency, and then there is a coalition agreement with CBAC, with the state of Connecticut as a whole.
But your statement is that this bill, as it is written, will violate those union agreements.
It violates the agreement we have directly with the Division of Criminal Justice. Mandatory subjects of collective bargaining include employee evaluations and employee discipline. And in this case, we even have a superseding language in our Appendix A of our contract saying that to be as much. The concern that we have is sections 2, subsection B and C, and subsection 4 seek to implement, without being collectively bargained, changes to the way prosecutors' evaluations may be used and changes potentially to the way prosecutors' discipline may be imposed. Okay. And that's not something we're looking to have happen, obviously. I think any union president would tell you that.
Okay. Just letting you know, and I was a special public defender, and I'm friends with Chris Parakilis, if you know him.
Yes, thank you, Senator.
He's a good guy. Thank you, Mr. Chair.
Thank you, Senator Kissel. Representative Staffstrom.
Thank you, Mr. Chair, and Attorney Stango. Good to see you again. Thanks for being with us. So one of the provisions I think you mentioned that you had concerns with was the provision whereby a member of the Criminal Justice Commission could refer a assistant state's attorney for disciplinary proceedings, correct?
Correct.
Okay. So you were here, obviously listening to the last couple pieces of testimony. I guess I'm having a tough time reconciling the notion that the division's position is that only the Criminal Justice Commission gets to weigh in on who the state's attorneys are. Only the Criminal Justice Commission has any authority at all to hire, and by association, presumably to fire. But what you're suggesting is that a member of that commission can't then refer someone for discipline, where an instance of some sort of misuse of office or other malfeasance is brought to their attention. It seems to me it's got to be kind of one way or the other, no?
Well, I was speaking with regard to having a member of the Criminal Justice Commission try to weigh in on potentially down the road having one of our people, one of my members, brought up for discipline when discipline is completely covered between our collectively bargained agreement between the Division of Criminal Justice and CAP. The concern I think that the division has with regard to having any member of the commission have the ability to raise an issue is oftentimes they are transient. They're not there for a tremendously long period of time. Oftentimes they are appointed and changed at the whim of the governor, which is the governor's right. And under those circumstances, sometimes they are prone to political pressure. Actually, we have a criminal defense lawyer on this particular commission who is beyond reproach as far as I'm concerned. I know him personally, but in the future, you never know. A member may have had a problem with something in their district or their part of the state or their family, or read something and want to see an individual prosecutor or individual state's attorney or an individual deputy chief brought up on charges when it might be an isolated incident, which really doesn't rise to a conflict within the division. So I think that's some of the concerns that we have. But for my unit, my members, we know that our discipline is governed by Article 13 of our unit agreement, and it's been collectively bargained, and any change in that would have to be collectively bargained.
Yeah, I guess we could get into the contract clause and the wage and hour argument alike about what the legislature's role is and not with respect to that. But I guess that wasn't quite the focus of my question. I think that the focus of my question was, so as I hear you saying, that your concern is an individual member of the commission shouldn't of their own be able to refer an assistant state's attorney for potential discipline proceedings. We're not saying they can unilaterally hand down discipline or anything like that. Just say, hey, I'm aware of an issue that happened with Assistant State's Attorney Smith. This should get looked into. And your concern with the legislature allowing that individual commission member to is you believe that individual commission member is or could be prone to political pressure and is not necessarily free from outside influence. And so if that's the argument, and if that's the case, then why should we have those same 6 people who are prone to political pressure and not free from outside influence have the last word on who selects the independent inspector general who's going to investigate police use of force instances?
Well, Chairman Stastrom, one issue here is the weighing in of an individual member of the Criminal Justice Commission to institute discipline. You're talking about and trying to question whether or not the commission themselves should have the final word on who the inspector general would be. I think the reason why that should be so is because I think if you had to hold up members of the legislature who are elected by their constituents, and members of the Criminal Justice Commission who are there as a political appointees with no one to answer to but their own conscience and the task put before them by the governor, I think, humbly speaking, I would think that the members of the legislature might be more prone to feeling political pressure, certainly, than members of the commission. I don't think the alternative of having it put in front of the legislature makes it any less susceptible to political pressure. I would argue that potentially it may make it more so.
So, and then let me ask you about this evaluation issue. So the concern is having you don't want the evaluations that are done of assistant state's attorneys to be viewed by the commission in their evaluation of, say, the chief state's attorney for Ansonia Milford. That correct?
Yes, and the reason why I say that is because our contract affords my members privacy rights in their individual evaluations. The evaluation process, which is ever evolving with us, is meant to assist the division in dealing with that particular employee. As I indicated, it's not meant to be used against non-unionized members of the Division of Criminal Justice, and because that would potentially expose individual members of mine, their histories and or disciplinary histories in a forum where it doesn't belong. There's FOI, which I think is always a possibility, but then even that affords my members rights with regard to the accessibility of those private individual records. Matter of fact, when I deal with disciplinary hearings with my members, I'm often in a situation where I don't even share what's going on with my other officers. I mean, there's a focus and a push to keep individuals' disciplinary situations private. I mean, they have that right, and it's afforded us in the collectively bargained agreement ratified by the legislature.
So what if, I mean, I think the import of this provision is part of what I think the Criminal Justice Commission should be looking at when they're evaluating a state's attorney for a particular judicial district is how well the employees working under that state's attorney are progressing or performing. As the head of an office, they're not, maybe the state's attorney, you tell me, but maybe the state's attorney for Ansonia Milford is getting in the courtroom, a couple times a month, a couple times a year, a couple high profile cases. But really what we should be evaluating is how well or not are they running their office? And are the employees under them progressing in their career or not? And are they doing their jobs well? And if not, what corrections are they making? So if we simply required that the names on the performance evaluations be redacted, or that only an employee number was available so that you could see the progression or lack thereof that folks in the department are making, or whether there's a trend in the comments in the performance evaluations, would that alleviate your concern?
Well, I hadn't thought of that until you mentioned it, Chairman Stafford, but I would suggest to you that it would be better than the current proposal. I'm not certain it would go all the way to alleviating my concerns, but in the heat of the moment here, I would say to you that's better than what's initially written, for sure, right? Because what happens then is, as you know, the Criminal Justice Commission hearings are now live. They are done in real time, in hopefully the near future back at the Legislative Office Building, in that lovely hearing room, or for now on Zoom. And so people are going to hear potentially specific information with regard to my members that should be kept private. But certainly anonymity, like you're suggesting, would be better than the proposal as written at this time.
Thank you, Mr. Chairman.
Thank you, Representative Stafford. Are there comments or questions from other members of the committee? Seeing none, thank you very much for joining us today and offering your opinion.
Senator Winfield, thank you for having me.
Absolutely. We will hear next from Brian Anderson, followed by Paul McElroy and Ryan Fazio. I see Brian. You may begin.
Thanks, Chairman Winfield. Good afternoon, Chairman Stafford, Chairman Winfield, members of the Judiciary Committee. My name is Brian Anderson. I'm a legislative coordinator for Council 4 AFSCME. Our union represents more than 2,000 Connecticut municipal police officers. Our union supports Senate Bill 666, an act concerning use of force by a police officer. This bill addresses an immediate problem. The new use of deadly force standard is scheduled to begin on April 1st of this year, yet police officers have not been trained in it. This bill resets the effective date to October 1st, 2022, allowing training to occur. This is a move in the right direction. It is vital for police officers to be trained in the new deadly force standard. It's a substantial change from the current standard, making training crucial. There has been great disagreement at the Capitol on policing matters, but maybe we can all agree that the date change in this bill benefits everyone involved in the debate over policing. It doesn't help anyone for police officers to face a new standard that they don't understand and have not yet been trained in. It is unusual for the state legislature to pass a bill as early in the session as this bill requires. We appreciate that this bill is written with the March 31st effective date, and we appreciate your considering it and putting it before your committee today.
Thank you, Senator Kissel. Senator Kissel, you're muted.
I messed up, sorry. Hey, Brian, it's great to see you.
You too, Senator.
I agree. I mean, you know, if we want to have different policies with our police officers, we need to have time for them to train. And it seems like that was your explicit message. And is that pretty much the direction of your comments? Is there anything else?
No, that is our strongest focus. And we know it's out of the norm for the legislature to pass a bill so early in the session. So we're really hoping to focus on that date.
It seems like a really simple request, in my humble opinion. I'm only one vote and I'm in the minority, but Brian, it's always good to see you.
You too, Senator.
Thank you, Mr. Chair.
Thank you, Senator Kissel. It's one important vote. Let's see. Rep. Fiorello.
Thank you, Mr. Chair. Mr. Anderson, as Senator Kissel said, your request seems simple, but can you comment if this bill does not go through? What do you see are the risks?
I think it would be really unfortunate to have a new standard take effect when our members haven't been trained in it. I do think there's some confusion. And I know Post is working on training. I know Chief Mello has been very active in making sure that a training regimen is shaping up. So I just think it behooves everyone to pass this piece of legislation, the date that's in this piece of legislation.
And the sense of confusion that you're saying, does that lead to police officers being more reactive, or what? How does that manifest itself in how we would see police officers doing their work?
It's hard for me to answer that question, but I think in policing, it really makes a lot of sense for folks to be well and thoroughly trained on any change that the legislature sees fit to make. So I think pushing this date back to a point where all officers can be trained really behooves all of us.
Okay, thank you, Mr. Anderson. Thank you, Mr. Chair.
Thank you, Representative. Are there other comments or questions from members of the committee? I do not see any, so thank you, Brian, for joining us again today.
Thanks, Mr. Chairman.
We'll next hear from Paul McElroy, followed by Ryan Fazio, followed by Mark Bivens.
Hello, sir. Can
You may, yes, I can hear you. You may begin your testimony.
Thank you, sir. I would like to thank this committee for taking the time to hear the opinion of a lowly civil servant. I appear today as a taxpayer, a private citizen, and someone who has over 20 years of law enforcement experience. Those various experiences have certainly shaped the way I look at the world. I hope that at some point today, my point of view will be taken seriously by this committee as it pertains to this bill and other portions of the bill not taken up here today. I make this statement with some level of trepidation, knowing that whatever I say here is a matter of public record. And should I have to use force, it will most likely be used against me. But because of the gravity of the situation that all police officers find themselves in today, I feel compelled to speak openly to a public body about this bill and its many deficiencies. What I hope to bring to bear today in this committee is a level of common sense from an officer's point of view. Police officers are human beings. They are not robots. We are not automatons. We make mistakes. Offenders make a conscious decision to resist arrest. Offenders choose to engage in car chases, to sell drugs, to steal. How is it the police are being held accountable and the criminals are not? I do not profess to be a legal scholar. I am not an attorney. The U.S. Supreme Court in Graham versus Connor set a national standard for the use of deadly force. These standards are reasonable and understood by police officers. These standards can be used in the heat of the moment when split-second decisions need to be made. We must also look carefully at the totality of the facts known by the police officer at the time that the force was used. No matter how compelling the evidence might be found later, using hindsight may seem to be. No matter how emotionally charged we may all feel after the use of deadly physical force, we cannot go back and subjectively rejudge what someone had to do in the split second. Again, when offenders are non-compliant. Part of this bill revolves around an officer's reasonable belief that someone has committed or attempted to commit a felony, which involves the infliction of serious physical injury. How is an officer in the field supposed to know that something is a felony or not? I bring one particular statute to your attention, reckless endangerment in the first degree. In essence, states someone with extreme indifference to human life causes the risk of serious physical injury to another. I want you to know this is a Class A misdemeanor, would not justify the use of force according to the bill before us. Remember, a firearm is brought to every single scenario when the police encounter someone. We are the ones bringing that firearm. An unarmed, non-compliant individual is literally seconds away from becoming an armed, deadly weapon. Every year, police officers are killed with their own firearms. There are many instances where officers have been beaten senseless by an offender. If you were sent to arrest Mike Tyson and he resisted, do you think any of you would win? I know I would lose. At what point would I be able to discharge my firearm against an unarmed assailant that far exceeds my physical capabilities? I am not alone in this assessment. I'm certain my colleagues across the country would agree with me. I am certain that the U.S. Supreme Court agrees using the Graham versus Connor standard. This bill also indicates the conduct of a police officer is somehow responsible for increasing the risk for the use of deadly force. I find it abhorrent and reckless that the legislative body would take away all responsibility from an offender's actions and place that responsibility completely on the shoulders of a police officer. That is what this bill does. Thank you for your time.
Thank you, Mr. McElroy. Are there comments or questions from members of the committee? Representative Fiorello.
Thank you, Mr. Chair. Thank you, Officer McElroy. Could you just explain to us what is your background as a police officer?
I retired from the state police after a little over 20 years of service. I was a uniformed trooper in both rural and urban areas. I was assigned to a federal task force for about 10 years. I was a road supervisor and also a BCI plainclothes supervisor. I've worked in narcotics, auto theft, organized crime. I've been lucky in my career. I've done quite a lot. I now work for a small town on the eastern side of Connecticut. So I guess you could say I've really seen every level of law enforcement that there is. And I've been an active participant at both the state, local, and federal level.
Thank you. Thank you so much for being here and being an officer who's willing to speak. I wanted to ask you, if the bill stands as it was written in the summer, and it says exhausted the reasonable alternatives, how can an officer exhaust reasonable alternatives?
I don't think you can. I think this very hearing is a great indication of that. We've had many learned people come here, and I know there were great intentions when this bill was put forward. There's always need for change in policing, but if we have been able to debate this topic for so long, for so many months, How can we reasonably expect a police officer in the heat of the moment to use this bill as a guide to what force they can and cannot use, with in the constant thought in the back of their mind, how much trouble am I going to get in for trying to do the right thing, which is my job?
What are reasonable alternatives to the use of deadly force?
Well, again, every application of force is different for every scenario. An officer that responds to a scene, the mere way that they park their car and approach a scene can affect what tactics are available to them. And every, let's say that a weapon that's considered less lethal may not be effective in a scenario. I may have knowledge of a person I'm dealing with ahead of time. I may have arrested them many times, and I know that they will come peacefully, even though they're boisterous. Conversely, I may know that every time the police come in contact with somebody, they fight us. And I do want the committee to understand that there are people out there that they're just not going to listen, and they're going to fight us every time we try to interact with them. There's no easy way to take somebody into custody when they don't want to go. There's no pretty way to get into a street fight with somebody. If it's going to happen, it's going to be ugly, it's going to be fast. And again, police officer always has a gun with him or her when they deal with somebody. It can be taken away. I think that's something that maybe the people who are not practitioners don't understand. To have that feeling when you're fighting somebody, perhaps even by yourself with no backup available, to feel somebody's hand go on your firearm, knowing that they're going to try to take it from you. It leaves you breathless and, alone. So to try and ask, what can I exhaust? It's split-second decisions, and it's difficult to go back and second guess somebody on those things. Should I have used OC spray on somebody? Should I have used a baton? And even if I had made those choices, there's no guarantee that they would have been effective. We have to understand that a use of force that's chosen by a police officer in a time of crisis, because that's what it is, and it's a time of crisis forced upon us by another person, we have limited time to run through a whole litany of what I could do and what's going to be the most effective. And I hope the least amount of force. A speaker earlier today said that, basically comparative force would be used. If you're in a boxing match with somebody, you can't trade blows with somebody and expect to win and expect to end the confrontation. The longer we allow the confrontation to go on, that will probably increase our need to use more force. I hope I'm making myself clear there that, again, the chosen application of force, we never want it to get to deadly force. Unfortunately, sometimes it can get there. Another factor would be size difference, right, between an officer and an offender, age difference, athletic ability. Not everybody's as strong as everybody else. I've had to fight with people who looked like they were maybe 100 pounds. I'm 6'5" and weigh 270 pounds. I had the toughest time getting them in handcuffs, using that amount of force that I could without hurting them. I don't want to testify in the stand and have somebody show up with a black eye. I don't want to give anyone a black eye, but these things happen. There's no pretty way to win a physical confrontation. There just isn't.
Earlier, we had some chiefs testify to new training that will be based on simulations, and that the definition of changing use of force is something that is significant. Do you think that simulated training is what will be helpful for police officers going forward? And if you could comment on the need for extra time, because this legislation before us is seeking to give more time for the implementation of this law.
Yes, I do think simulated training will be helpful. Again, the legislature speaks often about training. I'm curious if any additional funding or personnel has been set aside for post for this specific reason. I'm seeing a lot more of this now, again, at the municipal level. I didn't think much of it at the state level. of government before, but there are so many unfunded mandates that get pushed down to municipalities, this being one of them, that we simply can't keep up or train for them. We have 5 officers here where I work, and it will be difficult for the town to absorb these extra training costs. And on top of that, law enforcement training has always been fragmented. I think that's the best way to put it. It's done in blocks of training where you may receive training about mental health issues in one section, and then halfway through the year, then you have firearms training, and then 3 months later you have medical training. When we really should be evolving our training, I know you mentioned earlier about racing to an accident scene and what you do, all the things that go through an officer's mind. How can I get there safely? How do I identify witnesses and culprits? How do I render aid to the injured? This is really not how we train. We don't train in that holistic fashion. Suppose we go to the firing range about rendering aid to somebody immediately after a shooting. We know to do that, but it is not part of the continuum of training, but yet it's expected of us to do that. It doesn't become part of our muscle memory when our training is disjointed. I fear that part of this, the good meanings of this bill to restrain improper uses of force are not going to be adequately addressed in training. I think training, because this bill, I hope that it gets at least extended till October 1st for that reason. We need an extended period of time to make sure every police officer is properly trained. We want to do a good job for the public, but we can't do that if everything is rushed consistently and constantly in our profession. Hurry up and wait, get there, but don't spend any overtime on it because the state has mandated something but provided no funding.
Thank you. And my last question is, I appreciate you coming out to speak, and you expressed some nervousness in speaking out, but clearly you're speaking because you care. And could you speak about the impact that this confusion on use of force would have for recruitment? And when you have new officers or people who are thinking to enter this career and look to you as a mentor, you must speak about all the gratifying parts of the job, and yet use of force is a scary part of the work. How do you speak to someone who's thinking to become a police officer in Connecticut?
Well, I'm glad you brought that up. It's a great question. I've had this conversation with many young people who want to enter law enforcement, and I do tell them that, it's not like television. There's many hours of mundane time spent doing things you wouldn't imagine, but it is very fulfilling. It's a great thing to interact with the public and try and be helpful. The use of force thing is a problem. This bill, I think, has put a chilling effect on several aspects of law enforcement, on current officers now, what they're willing to do in their daily activities. And I believe I know that it has caused people to retire and to leave service early. I know police officers that have had between 2 and 5 years on that have left. I know people who have retired because of this bill. And as far as recruitment goes, to earlier portion of your question, I can tell you that it definitely affects recruitment. Our last recruitment portion here that we had, we looked for a certified police officer to come here to grow the program that we have in our small town, and we only got 1 applicant. And I think that speaks volumes. The prior time before that, I think we had 3. So this does have a chilling effect on recruitment and retention, and it's been a problem in that area.
Thank you, Officer McElroy, and thank you, Chairman.
Thank you, Representative Porter.
Thank you, Mr. Chair. One question that comes to mind, can you tell me how many police officers in the state of Connecticut have been killed with their own firearm through you, Mr. Chair?
Is that question to me or to the chairman?
I'm sorry, I didn't make that clear. That question is to you through the chair.
Yeah.
I don't know of any police officers in Connecticut that have been killed with their own firearm. I know I have fought with subjects that have attempted to relieve me of my firearm. I fought with somebody by myself, someone who would not listen. And I can tell you that's a scary thing, right? He didn't have a gun, but I did. And he wanted to take my gun. I can only assume what he wanted to do with it. I can tell you that every single year, police officers are killed with their own firearm. You can check the FBI statistics on that if you wish to find actual numbers. But if we're also going to use events in other parts of the country to assist us in getting a better use of force program here in the state, then we also have to open our eyes to what happens to police officers across the country, right? Instances can happen anywhere. And if one thing is good for one end of an issue, it's good for the other. We want a safe society. We want to be inclusive of people. We want to do the best job we can to help people and to be effective in law enforcement and to do it safely. If someone were to take a police officer's gun and murder him, he's on the run with the gun now. That doesn't make anybody safe.
Okay, so you said a lot there, and I just want clarity for the record. Yes and no. So you do not know of any Connecticut police officers that have been killed with their own firearm. Is that correct?
That's correct. Okay. But as a law enforcement officer, my training has to, in my experience, also includes those of brother and sister police officers. Okay. And an attempt is just a failed attempt doesn't mean that it would not have happened, ma'am.
Right, but it has not happened is the point that I'm trying to make. So thank you for responding to that. And I think the only thing that I will add to what I've said thus far throughout this public hearing is just to make sure that we keep coming back to the reason for the bill. And when we talk about fear, because I'm hearing a lot about fear and, concerns around police officers and fear for their life and what they, when they leave home to do their job. I can tell you that same fear, probably with a lot more potency, exists for Black people in America when we leave our house every single day. From something as simple as a traffic stop, which is nonviolent. You will not find anyone trying to fight a police officer, but simply getting pulled over for speeding, tail light, whatever it may be. So I'm going to keep coming back to the point of the reason this bill came before us, the reason this bill was passed in the summer of last year, and the need for this bill. And just remind people to please be mindful that when we take things into account, we take it all into account. And that this bill was brought forward to bring protection to the people who are being brutalized by police in their community. Thank you, Mr. Chair.
Thank you, Representative Porter. Representative Fishbein.
Thank you, Mr. Chairman. Mr. McElroy, I missed the part of your qualifications. I'm just trying to ascertain if there was an incident in Connecticut involving an officer having their firearm used against them. Is there some reporting requirement that it would go to you?
No, there's no specific reporting requirement that I'm aware of that would segregate someone taking a police officer's gun away from them.
Okay, and I'm just trying to ascertain in what acumen would you be asked to opine upon whether or not that has happened in the state of Connecticut? Is there some part of your job, your duties that would require some sort of your reporting or reporting to you if that were to happen?
Well, yes, if that were to happen to me, which it has happened to me, I would document that in my arrest report.
Yes, sir. But
right.
if it was to happen in Greenwich with a different police officer, and is there some requirement that it would be reported to Paul McElroy?
No, I would not be made aware of that.
Okay, so I'm just trying to figure out how you would know, you would be able to state that it's never happened in Connecticut. Is it fair to say you wouldn't
Correct,
be the person to ask that question of?
No, I'm not privy to that information. There's no separate reporting requirement that I'm aware of that shows attempt to take a police officer's firearm. It's just not a reportable requirement.
Thank you. Thank you, Mr. Chairman.
Thank you, Rep. Fishbein. And this is probably to that exchange a little bit, and I'm going to bring up something else, but I think I'm not going to speak for Representative Porter, but I'll speak for myself. One of the concerns I have sometimes when people come before us and they're suggesting something, like was suggested, that the issue of the gun being taken and the danger that comes from that is what information does that person have about these things happening? And so I'm going to ask you a question about something you talked about in your testimony, or at least in maybe an answer to Rep. Fiorello. I think that you suggested that the bill that we passed last year had an impact on recruitment. I think you said that it was actually not your supposition, but that you knew that it had an impact because of the one recruit. Is that correct?
That's correct. That's my personal experience here.
And when did this recruiting happen?
In January
of this year.
Mm-hmm.
And the difference between the last recruiting and this recruiting was you went from 3 to 1, correct?
Right.
And you haven't had a subsequent recruiting that had a lower number than the 3 since that?
Since January? No.
Yeah, since January. No. So you had one opportunity for recruiting, given that we are in the middle of a pandemic with all kinds of other issues, and you're absolutely sure, as you represented to this committee, that it was because of the bill. How could that be the case?
What I'm saying is I do believe that has had an impact on it. I, as a police officer, being retired, and now I'm on my second career to continue my public service, this is a constant thought in my mind. I've heard this from other police officers as well. So that's my basis for that statement. Is my observations, my experience, my personal belief, and in speaking with other police officers. Would you continue to do this job again? The answer has been no. I think that's borne out by the fact that we only had, I apologize, I think that was borne out by the fact that we only had one applicant. And even though it was during COVID, we've been doing online recruiting here for the last 2 years. We don't require it in person. Most police officers are familiar with the application that we use, and we've only had one person apply this last open period of recruiting.
Thank you. And I would just say that, and I've had this experience before, particularly with elected officials, police officers, police chiefs, senior police persons, anyone who is senior and whose testimony would be taken as fact. There's a difference between the suggestion that what I know suggests and I asked you this question, and what the person puts forward is, I know this to be a fact. That's why I asked you that question. I'm not trying to fight with you, but I think it's important when we represent something as factual that it is clear to the people listening whether it's actually factual or it's a very well-considered professional opinion, because it's important to the entirety of the conversation. I appreciate your commentary and your opinion. Are there other questions from members of the committee? I don't see any, so thank you, Mr. McElroy, for spending part of your day with us and offering us your opinion.
Thank you, Senator.
We'll next hear from Ryan Fazio, followed by Mark Bibbins, followed by, I can't read my high handwriting, but I'll get the last person. Is Ryan Fazio here?
I can't turn on my video for some reason, but I'll give my statement regardless. Thank you, Mr. Chairman and members of the Judiciary Committee. My name is Ryan Fazio. I'm a lifelong Connecticut resident and current member of the Greenwich RTM. I want to thank the committee for making this effort to listen and work across the aisle and improve our statutes. We all want to see every citizen of our state thrive in every facet of life. I am testifying today in support of raised Bill 6462 to improve police use of force policy in order to protect our state's most vulnerable citizens. I would like to use my time to address the backdrop against which this issue is being considered. On August 31st, a young woman and her unborn baby were killed in her bed by shots fired on the street outside her home in Bridgeport. Nothing can surpass the tragedy of young lives being taken violently from us. But what is worse is that tragedies like these are now becoming more and more common in Connecticut. In 2020, homicides in our state's 3 largest cities with available data, Bridgeport, Hartford, and New Haven, rose 35% year over year, and shootings increased by 57%. That's staggering. All of the increase in shootings came after Memorial Day against the backdrop of widespread protests against policing that were endorsed by some of Connecticut's political leaders. Violence got even worse from October onwards as several major provisions of the state's policing overhaul went into effect. The increase in shootings for the 2 large cities with weekly data available from CompStat, Hartford and New Haven, shows shootings increased by 22%, decreased by 22% from January through May of 2020. They increased by 66% from June through September, and increased by a staggering 125% since October to last week. The increase in homicides is evidently higher in Connecticut than around the country, and the violence is accelerating here, unlike nationwide, where it increased by the most in the summer. Our police bill has both good and bad in it, naturally, but it has also sent a clear message last summer that demoralized police officers and roused criminals. As its provisions started going into effect, violence increased, and without improvements like 6462, the danger to the public will get even worse. Overly restrictive use of force ties the hands of good police officers and puts lives in danger. It leads to explicit or implicit depolicing of vulnerable neighborhoods as police officers become more cautious. Violence fills the void in our most vulnerable neighborhoods. Defending the public safety is obviously the foremost responsibility of our government. Good, fair, and proactive policing without prejudice is indispensable to that end. To achieve that, I hope the General Assembly will confront the surge in violence in Connecticut, advance the raise bill, and pursue other changes to keep our people safe. Thank you for your time.
Thank you. Questions from the committee? Seeing none.
Sorry, I didn't have time to raise my hand, Representative.
Go ahead, Representative Porter, please.
Thank you. And just really quick, I found that interesting that we just heard that we're at the top of the list for violence. And I want to make sure that I understood that, because last time I checked, because I was looking for New Haven, New Haven was number 85, 2021. So I just want to put that out there. I'm a little frustrated because a lot of stuff is being said as if it's factual. And like the good senator just reminded us, I want people to do your homework, in these public hearings, make sure that you're checking and fact checking, because it's important that we get this right. And it is important that we do it collectively and collaboratively. And I'm hoping that's going to be the case moving forward. Thank you, Mr. Chair.
Thank you. Senator Kasser.
Thank you, Mr. Chair. So Mr. Fazio, you said that the increase in violence in Connecticut was due to demoralized police. Do you recognize possibly any other factors that might have caused an increase in violence? Perhaps the pandemic, perhaps an increase in gun sales?
Thank you for your question, Senator. So as I pointed out in my testimony, shootings actually decreased by 22% through Memorial Day of 2020. So in the early days of the pandemic, when it was at its apex, violence actually decreased in Connecticut. It wasn't until June when we saw a surge in violence, and it accelerated after October once some of the major provisions started going into place.
Thanks for your testimony.
Thank you.
Yeah, thank you, Senator. And I think that is an important point. Let's not forget that May was also the period in which someone's well, I'm gonna leave it alone. Thank you for being with us today, sir.
Thank you. Have a good day.
Next up will be Mark Bibbins.
And, excuse me, Mr. Chairman, Mr. Bibbins nor Mr. Moreau have decided to stay along with us at this time of the day.
Okay. Madam Administrator, do we have anyone else scheduled to testify?
No.
If not, I will declare this public hearing closed. I'll remind members of the committee that we are meeting earlier than normal on Wednesday. We will meet at 9:30. We need to get started promptly at 9:30 as the House is going into session later in the day. We'll be taking up the judicial confirmation hearing for Attorney Bob Clark to the appellate court and expect a vote following the public hearing. With that, we will see you all on Wednesday.